Hello, everybody. Oh. Hello, Ava. Hello, Nana Laura. Hello, my sweet T-Rex. Hello, Eileen E. Carlin. Oh, Ava's saying hi, too. Hello, Charlie. Oh, I'm so happy to see you guys. Hello, Billy. Big old Billy Fat Butt. He came up to get a snack. And yeah, he had to start that just as I started streaming so y'all could hear him. He's saying, "She's starving me." My goodness, Ava. Can I lift my arm, please? Hello, Donald Westerdale. Thank you for number 3. Hello, Ginny. You guys are just something. I love how intently focused she is. I swear, I was not given enough arms at birth. Every time the cat distribution system is at work and gives you another cat, it really should give you another set of arms. Here, you take that. You still have 2 more treats, but I know you'll be back. Yeah, that's what I thought. Set these off to the side because those are her blue buffalo, and you know she'll be back for them. So tonight, the first round of cases, I'll be honest, it's not about the cases. Not at all. I don't even know what the cases are. Probably the first 4, 5 of them. No. There is a defendant, and it is all about that box. I am so happy to see you. Thank you. Thank you for saying hi to everybody. Yeah, it's a thing, man. It's a thing. It really happens. Yeah, so I had a really funny thing happen, and I just, I'm going to share it with you guys because it makes me, I don't know what to do about it. I really don't. I don't know what to do. So I have this really great friend. We've known each other, I don't know, like 6 months-ish, maybe. She actually works for the company that does my medical transport. So she's my driver. And we have just become really close friends. And a couple, I don't know, I want to say a couple months ago maybe, I thought I was messaging her. And thank goodness it wasn't anything too terrible. But I'm a weird one. And I like sending people that I love just, little random messages and let them know that I'm thinking of them. It's just something nice I do. And so January 14th, so yeah, a couple months ago, I had sent her a message. She never replied to it, and I just thought maybe it was just a little too weird for her because that's me. I'm weird. And I realized yesterday when she had given me my ride to my appointment and back, I noticed that there's actually 2 Cassandras in my phone. And the one that I messaged, it wasn't her. It was actually, so my neighbor, he went to prison, and he had asked me if I would contact someone about his car. So I put them in my phone in case he needed me to reach out to them again. And that way I didn't have to look them up on his Snapchat and blah, 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 because messing with his phone's a big ordeal. And so, yeah, this woman that I have never met, I've talked to one time, have no idea who she is. Couldn't identify her from Adam. Seriously. She got a message on January 14th from me with pictures of me and the cats. And yeah, just really pretty pictures of me and Billy and Bandit. That's such a pretty picture of Bandit. And then Earl having a licky treat. And it just says, I have nothing to offer but glorious pictures of cats. Just a random message from me. Yep. I learned why my friend never responded to me. It wasn't her. So then now I've realized this, and it's been a couple months, and I'm like, okay, do I apologize and say, hey, I just realized that you're not the person that I thought you were. Sorry for the random pictures of my cats and me. Do I let them think that I'm this crazy lunatic that messaged them and they don't know me? Or do I just like let it die? Like, so like there's that big part of me that wants to be like, oh my God, I'm so sorry. I'm really not crazy. Just ignore that and pretend it never happened. And then there's that other part of me that's like, just ignore that and pretend it never happened. I don't know. Could be an Adam for all I know. Oh my gosh. No way. No. Say it ain't so. You keep that stuff to yourself. Hello, CE. So yeah, I'm thinking I just pretend it never happened. That's my thought process on that, you know? Eventually maybe they'll forget about it too. What? Rosanna Dana excuse. Never mind. I never do mind. Can't tell me what to do. Yeah, I know, but it's been a couple months now. Like, wouldn't that be weird? Like, re-bringing it up? I think, I don't know. I think that would be more creepy than just pretending it never happened. I don't know. But yeah, that I am so weird like that, you know? And if it, but I send messages like that to my very close knit circle of friends, you know, because I don't want people. I'd send it to everybody, but I don't want people to know I'm that weird, you know, until I completely embarrass myself, and then I'll share it on a international stage, you know. No problem with the internet knowing how weird I am once I make a fool of myself. Oh, yeah. Hello, Jenny Green, my love. And yes, they are. They're the most wonderful. Hello, she's a maker. Oh, thank you, Judy. That is so sweet, honey. Well, I needed you. I need you every night. Oh, see, I haven't watched that show for years. And Judy, honey, how do I say your last name? Is it Cake? Is it Cocky? Is it? Can you phonetically spell that for me, please? Because I want to say hello to you, but I do not want to get that wrong. And I don't want you to be upset with me if I get that wrong. I know that would have been my response. Who it is? That's what I say every time I get those absolute, they're scammer text messages where they're like, I'll see you at the train station at 5:40 and then we will have biscuits and tea. And it's like, no, we won't. Nope. We're not. Yeah, I think that's what I have to do. Golly, that was so embarrassing once I learned it. Oh. There have been some very solid friendships molded out of accidental text messages. It does happen. But nowadays, they're all scams. Thank you. Judy Cake. Welcome, honey. I'm so happy you're here. Army Brat 1964, I miss you. Hello, Loud Elvis. Oh my gosh. Somebody on Facebook Messenger messaged me and their username was Elvis something or other. And so I replied, is this Loud Elvis? And at first they said yes. And then they started like chatting me up and stuff. And I realized this person has no clue who I am. It was a scammer. They're just like, I saw your profile picture and you are absolutely beautiful and you brightened my day. And yeah, no. No. That's not true. Not at all. That is grand. Hey, I've gotten mail from AARP before because with being on Medicare, Medicaid, whatever it is, they just assume I'm old. Nope. Hello, Rando Calrissian. I'm so sorry. I probably butchered that. Calrissian? How would you like me to say that, please? Oh, you guys, I love having new people here. I really do. I love having new people here. I hate butchering your names. We'd like to contact you about your vehicle's extended warranty. No, probably not. Probably not. All right, guys, let's get into the fun. It really is. It's going to be a good time tonight. I can feel it. Oh, not that button. Wrong button. I even named it Y with 3 Y's at the end.
You can proceed with Mr. Balanga. Go on the record in the matter of the people state of Michigan versus Belonga, file 244672 SM and 244796 SM as well. Mr. Belonga, can you hear me?
Yes, I can hear you.
All right, go ahead and state your name. Mr. Wilson, I need you to stop moving around or at least mute yourself because whatever movements you're doing is coming through really loudly.
Kyle Boranji.
No, Mr. Wilson, yeah, okay.
More
All right,
than that.
Mr. Belonga, did you state your name? You did.
Yes, Kyle Boranji.
All right, very good. Ms. Strasser?
Tess Strasser, on behalf of Kyle Belonga, for the limited purpose of arraignment, we have reviewed the charging document and waive a formal reading. He's entering a plea of not guilty. We did conduct a screen for indigency and found he does qualify, so he will be receiving a court-appointed attorney. Request this matter be set for pre-trial and trial.
All right, we'll indicate a not guilty plea and set the matter for a jury trial, pre-trial in advance of that. We'll indicate court-appointed attorney has been appointed. In regard to the bond, we will identify bond at for each of the files at $200 personal recognizance.
Thank you, sir.
And sir, you're all set. You can leave the court. If you have any questions, follow with the public defender's office.
Thank you.
We can proceed with Ms. Bowen.
What? I got to catch up though. There were two of these, so let me get them both done.
As Judge Tammy says, I'll arraign him naked, just not spitting. Oh, he got a shirt on finally.
There's Mr. William or Mr. Tarrant.
All right, let's go ahead and do that quick.
Okay.
Well, at least, Mr. Burnett, you need a breakout room?
If I could for a moment, Your Honor.
All right.
Mr. Tarrant will have to, there he is.
Mr. Tarrant, we're going to need to put you into a breakout room with your attorney. We'll be, and as soon as you're done talking to him, we'll bring you right back in and address the competency hearing, okay? So you're going to need to accept the invitation. While they're doing that, Ms. Strasser, what case are we ready to proceed with?
Ms. Bowen.
Let's go on the record in the matter of the people state of Michigan versus Catherine Bowen. Ms. Bowen, can you hear me?
I can.
State your name.
Catherine Bowen.
All right, Ms. Strasser.
Strasser, on behalf of Ms. Bowen, for the limited purpose of arraignment, we have reviewed the charging document and waive a formal reading. She's entering a plea of not guilty. We did conduct a screen for indigency and found she does qualify, so she will be receiving a court-appointed attorney. We request this matter be set for pre-trial and trial.
We'll set the matter for enter a plea of not guilty, set the matter for a jury trial, pre-trial in advance of that. We'll indicate public defender representation. We'll continue the bond at $500 personal recognizance. Ma'am, you're all set. You can leave the court. If you need to, if you have any questions, you can follow up the public defender's office. Good luck to you, ma'am.
Thank you.
And you know, here we get to see he's all up on his skincare routine. He's putting moisturizer on, and you would think that this, you know, was over now that he's clothed, but I'm sorry to inform you, it's not.
You're welcome.
We can proceed with Mr. Ellis.
Sir Ellis, can you hear me?
Yes, I can, sir.
State your name, please.
Matthew Ellis.
This is in regard to file 250189SM and 244885SM. And go ahead, Ms. Strasser.
Tess Strasser, on behalf of Mr. Ellis, for the limited purpose of arraignment, we have reviewed the charging document and waived formal readings. He's entering 2 pleas of not guilty. We did conduct a screen for indigency and found he does qualify, so he will be receiving a court-appointed attorney. Request this matter be set for pre-trial and trial.
All right, in regard to both of these matters, we'll go ahead and indicate not guilty, set the matter for a jury trial, pretrial in advance of that. We'll indicate public defender representation on both of these. The bond is $500 personal recognizance on both of these, and the no contact order identified on each file will be continued. In regard to file 2448885 SM, that will be Zachary Lee Ellis. And then in regard to the other file, 250189 SM, will indicate not guilty, set the matter for a jury trial, pretrial in advance of that. There'll be public defender representation. We'll also continue bond on that file at $500 personal recognizance. And we'll also continue the no contact pertaining to Oliver Ellis. Sir, you're all set. You can leave the court. If you have any questions, follow with the public defender's office. All right.
Thank you, Your Honor.
You're welcome. Ms. Strasser,
We can proceed with Mr. Gould.
on the record in the matter of the People's State of Michigan versus Gould, file 250373 SM. Mr. Gould, can you hear me?
Yes, I can, sir.
State your name, please.
Timothy Gould.
Ms. Strasser.
Beth Strasser, on behalf of Mr. Gould, for the limited purpose of arraignment, we have reviewed the charging document and waive a formal reading. He's entering a plea of not guilty. We did conduct the screen for indigency and found he does qualify, so he will be receiving a court-appointed attorney. Request this matter be set for pretrial and trial.
Will indicate not guilty, set the matter for a jury trial, pretrial in advance of that. Will indicate public defender representation. Will also continue the bond on this matter, identified at $500 personal recognizance, and also continue the no contact order with Brita Bixler. And sir, you are all set. You can leave the court. If you have any questions, follow up with the public defender's office. Good luck to you.
All right, thank you, Your Honor.
Ms. Strasser.
We can proceed with Leland Deligan.
On the record in the matter of the People's State of Michigan versus Leland Ligon, file 250341FY. Mr. Ligon, would you state your name for the record, please?
Elon Ligon.
All right. And this is, make sure I have the right file here.
And I do believe we are now on the crapper with Leland. I'm almost positive.
Okay, very good. Go ahead, Ms. Strasser.
Beth Strasser, on behalf of Mr. Ligon, for the limited purpose of arraignment, we have reviewed the charging document and waive a formal reading. We did conduct a screen for indigency and found he does qualify, so he will be receiving a court-appointed attorney. Request this matter be set for probable cause and preliminary exam.
All right, the probable cause will be March 13, and the preliminary examination will be March 18. Will indicate public defender representation. Bond on this matter is currently $1,000 surety. We'll continue that. Sir, you're all set. You can leave the court. If you have any questions, follow up with the public defender's office. All right. Good luck to you.
All right.
Yes, please leave. That was just wild, guys. I do it on my Android phone all the time. I just hit @ and then I type the name exactly how it is in chat. If there's a space, you put the space. If there's not, you don't. You try to make sure autocorrect doesn't hijack whatever you've typed. And and boom, then it highlights for the person. But I do it on my phone all the time. Phones, computers, laptops. So you're telling me that iPhones don't allow you to tag people? I know iPhones don't play nice with YouTube because it's owned by Google and that's Android, but are they that petty? I have heard if you're on the iPhone browser and you are actually on the website, that you have more functions than you do in the app. So I don't know. I don't use iPhone kind of for this sort of thing. Hello, Nigel 1701. I am much better now that you're here. I can't believe he did it. I can't believe he did that. And oh my goodness. We don't get to see that far. That's what I thought. That is what I thought. Hello, Allison, honey. No, when we first started, he was not dressed at all. He was just fresh out the shower. And he even, when he set his phone down, you could see the steam in the room. Like, he literally just stepped out of that shower. That's crazy. Oh, that is, oh man, makes me not like them even more. But are you using iPhone? Because I'm using Android and my laptop, and I have no problem tagging. Okay. You just have to type it out on iPhone or iPad. Yeah. It doesn't do the auto suggest like laptops do. That part, that I know. Weird. Maybe it's the model that you have. I don't know. Yeah, it's just not compatible with me. Oh, you missed some dude in the shower who then took us to the crapper. Yeah, right. Wow. Yeah, I spent 7 years working for a cellular company, and I mostly did IT tech support type stuff. I got in when the internet was just barely starting in its infancy on phones. Yeah, 2007. That was when I started. And BlackBerry had just come out with their very first color screen shortly thereafter, the BlackBerry 8703E. And so, yeah, that was, like I'm saying, it was early in internet on phones. And I had to work on a lot of iPhones, a lot. And I didn't like their platform. I didn't like their software, their format, anything about them. For me, they were more difficult because they were less customizable. I like having the ability to, to do what I want to do, and I can't on iPhone. I saw Nana Laura's comment before I saw yours, Ma, but I knew that what yours was going to be. Oh, yeah. See, I don't know if I do that on my phone or not when I tag. I'm not sure. I'll let you guys just sit there and play around with that in the chat.
Mr. Baber, can you tell me which case you're appearing on this morning?
Yes, Your Honor. I have a notice to appear today for what appears to be a contempt hearing for Mr. Conradi.
Okay, sounds good. Thank you. All right, Mr. Conradi, I've got you connected. If you're there, can you, there we go. All right, Mr. Conradi, are you able to hear me okay?
Yes.
Okay. All right, so we're on the record. This is Crabtree versus Conradi, case number 0812760. The record should reflect Mr. Conradi is present today by video. We do have Mr. Baber here as defense counsel. Ms. Kraus is present on behalf of friend of the court. This is set today as a show cause hearing. Mr. Conradi, it appears, and Ms. Kraus, correct me if I'm wrong, it appears he was arrested on a bench warrant. Is that correct, for non-payment of support?
Correct.
Okay. And so Ms. Kraus, how does the friend of the court want to go forward today?
The friend of the court would request a contempt hearing pursuant to the referee's recommendation and from the last hearing in front of your honor, as he was to be in contact upon his release as well.
Okay. And there has been no contact?
There has not.
All right, and would this be a first or subsequent finding of contempt?
This would be at least the second subsequential finding.
Okay. All right, Mr. Conradi, I'm just going to go through a few things with you with regard to your rights. First of all, you do have the right to have a hearing as to whether or not you should be found in contempt. If you are found guilty of contempt, the maximum penalty you could face, because it would be a subsequent finding, would be up to 90 days in jail. Do you understand that?
Oh, yeah.
Okay. Mr. Baber, have you had any contact with Mr. Conradi prior to today?
I have not, Judge, and that's why I was, well, I take that back. I had contact with Mr. Conradi as he was bonding out of jail briefly. I got some background information. I did make a couple attempts to contact Mr. Conradi and left voicemails at what appeared to be his cell phone number. Because of the limited contact with Mr. Conradi, I'm not able to perform my duties as required under the professional rules of conduct. So I'd like this court to maybe consider doing an adjournment in this. This will give me an opportunity to talk with Mr. Conradi and give him an opportunity to talk to the friend of the court. And we could set this for a formal hearing at a later date if the court's willing to go that way.
All right, Mr. Conradi, how do you want to proceed today? I mean, Mr. Baber's here. He's been appointed to represent you. If you want to, challenge the contempt in this case. So how do you want to proceed?
Yeah, that sounds fine.
What? How did you want to proceed?
I guess as the lawyer was asking.
All right. Have you received messages from Mr. Baber? Why have you not contacted him?
I have to check my messages. I guess I haven't noticed any calls or whatnot.
If I may, with the court's permission, confirm phone number virtually this morning.
I don't want to do that here because this is being broadcast for public access. So rather not have Mr. Conradi put contact information out. Mr. Conradi, it's going to be up to you to get in touch with Mr. Baber. He's your attorney. He's being appointed to represent you. If you're not going to check your messages or call him back, I'm not going to adjourn this hearing further. Okay.
Yeah. Well, of course. Yeah, I will. I didn't realize.
What didn't you realize?
Oh, he had tried to get a hold of me, or I forgot about. I didn't get a hold of the FOC also. Otherwise, I would have.
Okay. You got arrested on this, right? And you were taken to jail.
Yeah.
And you had to post bond to get out of jail.
Yeah.
So you knew all of this was going on, right?
Yeah, I didn't realize, I had to contact them right away after getting released. Because after that, I went right to Mackinac, and I didn't realize.
All right, that doesn't make a whole lot of sense to me. When somebody's arrested for contempt, they have to post bond to get out of jail, and then you didn't realize you had to do anything to follow up on that after? Did you think it was going to go away, or what did you think was going to happen?
No, I didn't realize I had to contact the FOC after being released right away.
All right, well, I'm sure that was part of the release orders and the paperwork that you were given. Did you read any of that?
Yeah, I got some paperwork, yeah.
Okay. So I'm going to require that you get into contact with Mr. Baber, your attorney, and the friend of the court office, and especially the friend of the court office. You need to contact them before the close of business today. Okay.
Okay.
Then the court will set this for a contempt hearing. Ms. Kraus, I'm going to set aside an hour for that hearing, and Mr. Baber. The court will send out notice of the date and time of that hearing.
Thank you, Judge.
Ms. Kraus, anything else that we need to address on this file for today?
I do just want to indicate that the balance, this is an arrears only case. The balance is $17,154.79. The last payment was received back in February of 2023 from a prior income withholding. And then outside of that, he did indicate that when he was pulled over, he was earning income door dashing.
Okay. All right, and Ms. Kraus, Mr. Baber can contact your office if he wants to confirm the contact information.
That would be great. And then possibly, since he's to contact us, hopefully between the two of us, we would have good information then.
Perfect. All right, thank you. Do you have any questions, Mr. Conradi?
No.
Okay, thank you. That's all for today. And parties on this case are free to disconnect at this time.
Thank you. Be in touch, Mr. Conradi.
Okay.
All right, guys. Got an FTC.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Benjamin Lee Parmenter III, case number 2024 CR284. Amber Norris appearing for the state of Kansas, Joshua Andrews as defense counsel. The defendant appears in the office of his attorney. This matter comes before the court at this time for pretrial conference. Mr. Andrews, what announcement is made at this time?
Your Honor, before we went on the record, I was discussing a plea offer with my client. It was my understanding that it's a global plea offer that involves multiple cases. It was my understanding that his attorney in one of the other cases had already gone over this agreement with him in detail. He had indicated that actually had not occurred, that there was some mention of it, but it wasn't referenced in detail. So I was attempting to go over it with him. I was going to see if it would be possible to have a brief 5-minute recess so that I could continue discussing the plea offer with him and see if that's something that he wants to move forward with.
All right, the court will allow that recess at this time. We'll reconvene in approximately 5 to 10 minutes.
Thank you, Your Honor.
Following a brief recess, the court resumes proceedings in State versus Parmenter, 24 CR 284. Ms. Norris, Mr. Andrews, Mr. Parmenter appearing as before. What announcement is made at this time, Mr. Andrews?
Thank you, Your Honor. Your Honor, my client has accepted the global plea offer that was made. I would like to announce the global agreement that resolves all the cases and then proceed with the actual plea in this case, with the expectation that Mr. Parmenter will enter the appropriate plea in the other case when that case comes up with his attorney in that matter and in front of whichever judge that's set in front of. So the global plea agreement is that in this case 24 CR 284, Mr. Parmenter is going to enter a plea of guilty to counts 2, aggravated assault, a level 7 person felony. Count 4, violation of protective order, a class A person misdemeanor. Count 5, theft, a class A non-person misdemeanor. And count 6, domestic battery, a class B person misdemeanor. In case 24 CR 356, Mr. Parmenter will enter a plea of guilty to an amended count 1 residential burglary, a level 7 person felony. In exchange for the successful entry of pleas in these 2 cases, the state will dismiss cases 24 CR 395 and 24 CR 222 in their entirety. At time of sentencing, the state will recommend the mid-box sentences, follow the presumption, and have the cases 24 CR 284 and 24 CR 356 run consecutive.
Way things go, Mr. Andrews, the court would contemplate that this case will proceed to sentencing first. Where is he expected to be on the grid?
Your Honor, our understanding of his criminal history is that he would be a criminal history score of C in this matter.
Very well. Ms. Norris, has Mr. Andrews announced consistently with your understanding as to how this case would be handled?
Your Honor, that is accurate. And I would note for the court that there is an amended information in this matter that was filed November 25th.
I have it before me.
Okay. Thank you.
Thank you. Mr. Parmenter.
Yes, sir.
Okay, I just want to make sure our audio is good. I have a number of questions I'm going to need to ask you regarding taking of the pleas to these various charges. If there's anything asked of you that you do not fully understand, I will give you the opportunity to ask for further advice from your attorney along the way. Just let the court know if you need to get further advice from your lawyer, okay?
Okay.
And I will need you to speak up when you answer. I want to make sure all participants can hear you clearly. All right, state your full legal name for the record.
Benjamin Lee Parmenter III,
How old are you right now?
34,
What's the highest level of education that you've attained?
8th grade, but I'm planning on going back to school.
All right. Now, do you believe you're going to have difficulty understanding any of the legal concepts that we're going to be discussing in court here this morning?
Some of it, but I can ask my attorney.
All right. Have you ever been adjudged to be mentally ill?
Not that I know of.
All right. Are you currently under the influence of alcohol or any drug?
No, sir.
Mr. Parmenter, are you taking any prescription medication right now?
I'm supposed to. I'm working on getting back to the Central Mental Health Department to get my medicine back and stuff like that. And I was seeing can't think of the name, a counselor up there to help me with stuff.
Mr.
So,
Parmenter, from your statements, the court understands that you generally are supposed to be taking some sort of mental health medications. Is that correct?
yes,
But you're not taking them right now.
no,
Okay, well, Mr. Parmenter, what I'm trying to get to is I just want to make sure that you have a full understanding of what's going on in court. If those medications are necessary for that to happen, that's an important consideration here. Do you believe you understand what's going on today?
yes, a little bit.
Okay, well, you have to understand more than a little bit, Mr. Parmenter. Now we're gonna go slowly here. We're gonna cover a lot of different things to help you understand it. But you bother me when you say you only understand things a little bit. Now, you did get an opportunity to talk to Mr. Andrews this morning. Is that right?
Yes, sir.
Okay. And you're aware of the charges that it's been announced that you're going to be entering a plea to here today.
Yes, sir.
Okay. Now, do you understand the nature of the charge of aggravated assault?
Yes, kind of.
Well, okay. The state alleges that a fellow by the name of Ricky Abbott was placed in reasonable apprehension of immediate bodily harm by you with a deadly weapon, which in this case was a motor vehicle. You understand that that's the charge?
Yes, sir.
Okay, so do you understand what aggravated assault is in the context of this case?
Yes, sir.
All right. Count 4 is violation of a protective order. There, Patricia Lentz apparently has some sort of restraining order against you as a condition of bond in one of your other cases, and the state alleges that you violated that protection order, that bond condition. You understand the nature of that charge?
Yes, sir.
Okay. Count 5 involves theft. Apparently, allegedly, you took some purple eyeglasses from Patricia Lentz without that person's consent with the intention to steal it from her. You understand the nature of that charge?
Yes, sir.
And then count 6 is domestic battery, where the state alleges that Patricia Lentz is someone that you've had a dating relationship with or a household relationship with, and that you caused physical contact with her in a rude, angry, or insulting manner. So do you understand domestic battery?
Yes, sir.
You understand that when you enter pleas of guilty, you're admitting these acts that have been charged by the state.
Yes, sir.
You also understand that when you enter pleas of guilty, you give up any legal defenses that you might have had to these charges.
Yes, sir.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses at your trial and present evidence on your own behalf and subpoena your own witnesses to court?
Yes, sir.
You also understand that in such a trial, Mr. Palmer, you would have a privilege against self-incrimination, which means that if you wanted to testify in your case and explain your side of the story, you could at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Yes, sir.
You understand that when you enter pleas of guilty, you give up these valuable trial rights that the court has described.
Yes, sir.
Are you aware that you have a right to a trial by jury and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes, sir.
You understand that when you enter pleas of guilty, you give up your right to a trial by jury and the requirement to be found guilty beyond a reasonable doubt.
Yes, sir.
All right. You understand that you have a right to appeal a guilty verdict if you have a trial.
Yes, sir.
You further understand that you may appeal your sentence after entering pleas of guilty, but generally you may not appeal your judgments of conviction after you enter such pleas.
Yes, sir.
All right, Mr. Parmenter, are you aware of the sentences that could be imposed as a result of these guilty pleas that you're attempting to make?
Yes, sir.
All right, let's go over these. Aggravated assault is a level 7 felony. Do you have a copy of the non-drug offense grid under the Kansas Sentencing Guidelines Act before you?
Yes, sir.
If you look at the level 7 line all the way over to the right, in criminal history category I, you could receive as little as an 11-month sentence. Over in the worst criminal history category of A, you could receive up to a 34-month sentence. So the sentencing range is 11 to 34 months in prison, depending on your criminal history. As you sit today, we do not know with certainty what your criminal history is. You better than anyone else here really should know what your own criminal record looks like. But that will be researched by the Court Services Department, and based on the outcome of that research, as of the date of your sentencing, that determines where you fall along the level 7 line, and then you'll be sentenced accordingly. You understand that?
Yes, sir.
You also understand that at level 7, categories A and B, if your criminal history puts you there, are presumptive prison under Kansas law. Do you understand that?
Yes, sir.
Okay. You also understand that you could receive up to a $100,000 fine for that offense?
Yes, sir.
All right. Count 4 is violation of a protective order, a Class A person misdemeanor. Class A misdemeanors such as counts 4 and 5, the theft count, are punishable by up to 1 year in the county jail and up to a $2,500 fine or both. Do you understand that?
Yes, sir.
All right. Domestic battery is a Class B person misdemeanor. Class B misdemeanors generally are punishable by up to 6 months in the county jail and up to a $1,000 fine. Do you understand that?
Yes, sir.
Okay. There also may be some mandatory requirements should you get probation to complete a domestic violence program of some sort. Do you understand that?
Yes, sir.
All right. In addition to any fines that could be imposed, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders?
Yes, sir.
You also understand that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the
Yes.
court at the time of sentencing.
Yes, sir.
You understand that both probation and post-release supervision periods start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes, sir.
All right. You also understand that aggravated assault is a violent crime, could subject you to offender registration requirements under Kansas law.
Yes, sir.
All right. You understand the differences, Mr. Parmenter, between concurrent and consecutive sentencing?
Yeah.
Let's go over that.
Yes.
You've got a number of charges pending. If
Yes.
the court were to run those all together at the same time, that's what we call concurrent. That means when you're serving one, you're also serving the others.
Okay.
Consecutive sentencing means boxcard, back to back. You serve one, then you start the next, which obviously results in a much longer sentence. You understand that generally it's up to the court to determine whether your cases or your counts run consecutively or concurrently.
Yes, sir.
All right. You also understand that the Kansas Sentencing Guidelines Act is much more than the grid, which I think Mr. Andrews put before you earlier. It's an entire book of sentencing rules and laws. Do you understand that if any
Right.
special rules apply to you in your situation, it could affect your eligibility for probation or otherwise affect your sentence? Do you understand that?
Yes, sir.
Now, have you had an ample opportunity to discuss legal matters like that with your attorney, Mr. Andrews, before proceeding here today? Mr. Parmenter?
Yes.
Okay. Do you want any more time with him privately now before we go further?
Do you have any questions for me?
And yeah.
Okay. Mr.
Not
Parmenter,
right here.
I'm not
Not
sure I
right
heard your
offhand.
answer.
Not right offhand. I don't have any questions for him.
Okay. All right. So you're ready to go forward?
Yeah, I just want to get this over with.
Okay. Well, are you satisfied with the services and advice given to you by your attorney?
Yes.
Okay. Now, these guilty pleas that you're attempting to make, have they been based upon any threat or promises as to what this court will do in regards to your sentencing or any other type of threat or promise?
No, sir.
Okay. Do you think that what the attorneys announced earlier regarding a plea agreement is accurate?
Yes, sir.
Is there anything else that you thought was part of this plea deal that hasn't been accurately announced on the record already?
No, sir.
Okay. I want to make sure you understand, Mr. Parmenter, that there are any plea discussions or agreements between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes, sir.
So let me ask you, how do you formally plead to the charge in count 2, aggravated assault?
Guilty.
Count 4, violation of a protective order?
Guilty.
Theft, a misdemeanor count in count 5?
Guilty.
And count 6, domestic battery?
Guilty.
According to the state's charging document, all of this took place June 11 of 2024. Is that when it happened, Mr. Parmenter?
Yes, sir.
And it happened somewhere in Butler County, Kansas. Where was it, Mr. Parmenter?
Exactly the address.
You know, I don't need an address. Tell me the town it was in.
Leon, Kansas.
Okay. Now in count two, it's alleged that you used a Nissan Armada to place Ricky Abbott in reasonable apprehension of immediate bodily harm. Did you do that?
Yes.
You swerved or drove at him? Is that correct?
Yes.
Okay. And that obviously scared him, didn't it?
I guess it did.
Okay.
Oh, I don't know. A 2,000-pound missile coming at me. Sounds kind of scary. With a madman behind the wheel? Yeah. I'd be a little terrified. Might need a change of shorts.
Count four alleges violation of a protective order. Do you acknowledge that you had a bond condition in 24 CR 222 involving Patricia Lentz?
Yes, sir.
And that you violated it by having contact with her in defiance of that order. Is that correct?
Yes, sir.
Okay. And that in count five, the theft count, did you take purple eyeglasses from Patricia?
Yes.
Okay. Essentially, you stole them from her. Is that correct?
Yes.
Okay. And in count six, domestic battery involves Patricia Lentz also, and that you apparently caused some sort of physical contact. What was it, Mr. Parmenter? What happened between you and Patricia?
I slapped her.
Okay. And who is Patricia in relation to you?
That's my wife.
Okay. All right, Mr. Parmenter, then do you make pleas of guilty and accept conviction for aggravated assault in count two, violation of a protective order in count four, theft in count five, and domestic battery in count six?
Yes, sir.
And you're doing this freely and knowingly and voluntarily. Is that right, Mr. Parmenter?
Yes, sir.
Okay. I'll ask the prosecuting attorney, do you know of any legal reason why the court shouldn't accept this defendant's pleas?
No, Your Honor.
Mr. Andrews, this defense counsel, are you aware of any such reason?
No, Your Honor.
Mr. Parmenter, let me ask you, do you know of a legal reason or any other good reason why the court shouldn't accept your pleas here today?
No.
Court will accept the guilty pleas made by this defendant and finds that those pleas are made voluntarily. He has an understanding of the nature of his charges and the consequences of his plea, and a factual basis for each charge does exist. The court finds the defendant guilty and adjudges him therefore convicted of aggravated assault, a level 7 person felony in count 2, violation of a protective order, a class A person misdemeanor in count 4, count 5, theft, a class A non-person misdemeanor, and that is count 5, and then count 6, domestic battery, a class B person misdemeanor. The other charges of the information or amended information are dismissed pursuant to plea agreement. Court will order a pre-sentence report be completed to accurately determine Mr. Parmenter's criminal history, and the court will set an appropriate date for sentencing. Mr. Parmenter, if I had my choice, I'd go ahead and sentence you right now, but I can't do that because there's a process that has to be followed to research your criminal history. You may also be asked to do some risk needs assessments or something for court services.
Okay.
It takes time. I normally allow about 8 weeks for that, but that puts me right in the middle of a jury trial week. So I'm going to have to go out one more week from there. And I'm looking at the date of Monday, March 3, and I'm looking at a 1:00 p.m. setting, Mr. Andrews.
That works for me, Your Honor.
All right. 1:00 p.m. Monday, March 3. Mr. Parmenter, I'm going to keep you under your bond at this point. But one additional condition of that bond is that you have to fully cooperate with the court services department. Now, before you leave your attorney's office, I'm going to have Mr. Andrews give a call to the court services department in Butler County. They're going to give you direction about what you need to do next. Make sure you follow those directions, okay?
Okay.
And if you don't complete the assessments that are necessary and it causes a delay in sentencing, I'm going to hold you responsible for that.
Yes, sir.
Okay. So I know Mr. Andrews will get you started by calling them just as soon as we get done.
Yes, Your Honor.
All right.
Your Honor, just so that I make sure, is the sentencing hearing going to be by Zoom as well?
I'm going to address that. Yes, that's currently what I contemplate. But Mr. Parmenter, I'm going to order you to appear at the Butler County Judicial Center. I'm sure you've appeared for court there before.
Yes, sir.
You're going to have to participate from that building and that building only. Okay.
Okay.
Your attorney can make his choice about where he participates from, but I need you at that building that day. All
Okay.
right. Butler County Judicial Center, El Dorado, Kansas. And no other location.
And bring your toothbrush because you may stay a while.
Okay.
All right. Ms. Norris, are you aware of anything further that this court needs to address in the 284 case at this time?
No, Your Honor. Thank you.
All right. Mr. Andrews, are you aware of anything further that needs to be addressed?
No, Your Honor.
All right, Mr. Parmenter, we've covered a lot of ground this morning. Do you have any questions to address the court about regarding what we've done today?
No, sir.
Okay. Again, your attorney is going to call court services. And again, just follow their direction about how to get started and completed with your pre-sentence investigation process. Okay.
Okay. I'll do that.
Very good. And make sure that if you've got any other court dates in any other division, that you make all those court dates. Okay, Mr. Parmenter?
Okay.
All right, real good. And if there's nothing further, then
Been doing
Benjamin
pretty good
Parmenter
about it.
matter will currently be in recess, and this meeting may be ended for all at this time. Then the District Court of Butler County, Kansas, case entitled State of Kansas versus Benjamin Lee Parmenter III. It's case number 2024 CR 284. Amber Norris appears for the state of Kansas. Joshua Andrews is defense counsel. The defendant, for some reason, is in the office of his attorney. Mr. Parmenter, the court's docket notes indicate that you appeared before this court on December the 31st. At that time, you pled guilty to 4 counts: aggravated assault, violation of a protection order, misdemeanor theft, and domestic violence battery. A pre-sentence report was ordered. You were ordered to comply with assessments. Sentencing was set for today, and with you ordered to appear at the Butler County Judicial Center and nowhere else. Since it's
Your Honor.
Yes,
that's my fault. That's my fault, Your Honor. I forgot that the court had ordered that, and I didn't look back at my notes. And my client called me this morning to confirm where he was supposed to be. I knew since getting the pre-sentence investigation report that this was a presumptive probation case, and I just forgot and didn't look back at my notes to see that the court had ordered him to appear at the courthouse. So I told him to be in my office with me, to not log in remotely by Zoom, but that to be in my office with me. So I apologize, Your Honor. That was inadvertent, and I take full responsibility for that.
But why does he need you to hold his hand? Why can't he, put it into his calendar with a little note at the bottom? I don't know, use a Post-it note, write it backwards on his forehead with a Sharpie so it's forwards when he looks in the mirror. I mean, come on. The judge was very clear about that.
Well, Mr. Andrews, I will tell you, like I've told other defense attorneys in a similar situation, the first question you should ask your client in that situation where you receive a call like that is, did the judge specifically tell you to appear at the courthouse or anywhere else in particular? And if you don't do that, you're dropping the ball, counsel, because Mr. Palmer was told he should have remembered where he was told to participate. He shouldn't have had to have checked with you. I was very clear about where I wanted him to appear at, and he's just defied me on this. And you telling him the wrong thing doesn't get him out of it as far as the court's concerned. Mr. Parmenter, when you're instructed by the court to appear a certain way at a certain place and nowhere else, that's what I put in my notes, nowhere else, that's exactly what I meant.
Yes, sir.
And your attorney can't get you out of that. Right. The matter is before the court today for sentencing. Court does have a pre-sentence report compiled by Ryan Smith, pre-sentence investigator. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history which is stated in this report?
No, Your Honor.
Is there any objection by the defense?
No, Your Honor.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to the primary count in this case is criminal history score C, and the court will proceed further accordingly. Ms. Norris, are you aware of any legal reason why sentence should not be pronounced in the Parmenter case at this time?
No, Your Honor.
Mr. Andrews, are you aware of any such legal reason?
No, Your Honor.
Mr. Parmenter, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing at this time?
No, Your Honor.
Counsel, I'm not aware that there's been a motion for a departure sentence or any other type of sentencing related motion to take up. Is the state aware of any such motions that need to be pursued?
No, Your Honor.
Does the defense have any such departure or other sentencing related motions to pursue? Mr. Andrews?
No, Your Honor. No, Your Honor.
All right. Are there any victims or members of a victim's family present who desires to address the court in relation to the Parmenter sentencing?
Yes, Your Honor.
Okay. And you are?
My name's Patricia Lentz and I'm his wife.
All right. And what is your statement to the court? I will need you just to remain stationary. I don't want to get motion sickness as I watch your screen.
I would just like to start off by saying that I'm 100% fully aware of my husband's past history. And unfortunately, as a judge that I feel that you only get to see the parts of his life that come across your desk in the forms of bad decisions. I'm sure you're aware that my husband is an ex-addict and had a bad history because of it and a lot of criminal charges. But I would also like to note that in the last 7 years, since Benjamin and I have been together, he has not had any criminal charges up to this point, aside from traffic violations. No criminal charges, no felonies. Who my husband was back then is not who he is today. My husband found out that he was expecting his first child a little over 11 years ago and willingly committed himself in Osawatomie Mental Hospital to help him get back on his medication, as my husband is diagnosed bipolar, and to help him get sober so he could be the dad his daughter deserves. My husband's been sober for 11 years as of October of 2024, but not everything about him has been mistakes and bad choices. I'm here to tell you that there's good sides of him as well, and I'm not innocent in this situation. I was unfaithful many times in our marriage, causing rocky grounds and lots of arguments. And the particular night in question, I had conversations with other men because I was angry with my husband, and I sent him screenshots of the conversations. I'm not excusing his behavior or mine, as I'm sure that he knows what he did was wrong as well. I'm just asking for a little leniency. My husband and I do have 6 beautiful children together, 3 that we previously had, and 3 that we've had together in the last 7 years. We were living in his mom's attic and had nothing to our names when we moved in together. And now we own our own home and vehicles, mostly because of my husband. He's been the sole financial provider for our family for 6 years. And while he may not have been the best husband, at times due to issues on both sides, he's always been an amazing dad to our children. My husband worked every day. He'd leave at 4:30 in the morning to be at work and be home by 5:30, or not get home until 5:30 in the evening. My husband hated missing work and was always worried about getting wrote up and called in. And he let his medications appointments fall to the side, causing things to become tense and his mental health to start suffering. I've been fortunate enough to be able to be a stay-at-home mom since my husband and I got together. After working all day, he would still come home, make dinner for our family, and help get the children bathed for school and help them get to bed and tuck them in every night. The situation has had a detrimental impact on our children's lives. He's never had to miss a school event or a school conference, or our son's a state champion wrestler, and he's missing school events that he's never had to miss before because of these situations.
I'm just curious, like, he did all that, working those hours, coming home, making dinner, putting the kids to bed, giving the kids baths, all that stuff. What did you do? Other than cheat on him and then send him screenshots of you having conversations with other men. I'm sorry, I don't like this one.
I just want all this to be wrapped up and over with, and I want my kids to be okay, and my husband to get back on his medication and amend the damage that all this has caused our family.
Very well. Thank you for your statement. Is there anyone else who's a victim or a victim's family member who intends to address the court in relation to this sentencing? Where finds no other persons present. At this time, the court will ask for recommendations from counsel regarding an appropriate sentence for Mr. Parmenter, beginning with Amber Norris on behalf of the state of Kansas.
Thank you, Your Honor. Regarding count 2, the aggravated assault, would ask the court assign defendant to the mid-range sentence of 27 months. Defendant would be able to earn up to 20% good time credit and would be subject to 12 months post-release if necessary. Defendant has earned 2 days of jail time credit in this case. Regarding count 4, violation of protective order, 12 months in the county jail. Count 5, a theft, 12 months in the county jail. And second time DV battery for count 6, 12 months in the county jail. Would ask these counts run concurrent but consecutive to case number 24 CR 356, which was sentenced not too long ago in front of Judge Satterfield. Would ask the court to place defendant on 24 months community corrections probation with all standard and PSI recommended probation conditions. Your Honor, having completed domestic violence offender assessment, we'd also ask that he continue with mental health and that he take medications as prescribed. And that, as the court may have noted, Ms. Lentz, the victim, did note that he has in the past let his medications expire. We'd ask that he not do that. I think that's one of the reasons why he got in so much trouble and in all of these cases that he had. So we would ask that he continue with mental health treatment and that he keep up to date on his medication management and take the meds as prescribed. And Your Honor, I do know that Ms. Lentz does not wish to have a no contact, although the other victim, who is Ricky Abbott, I do believe we ask that the no contact be maintained regarding him. And Your Honor, the court will need to address the costs and fees of the action, supervision fees with community corrections. I believe Mr. Andrews is appointed, and we would ask the court address court-appointed attorney's fees and the bids application fee. State's not requesting a fine, and I don't believe any restitution was requested. I don't think I have any further recommendations for the court at this time. Thank you.
Very well. Mr. Andrews, your recommendations regarding an appropriate sentence?
Thank you, Your Honor. Your Honor, we would recommend a controlling sentence on count 2, the primary offense, of 27 months. A controlling sentence on count 4 of 12 months in the county jail. A controlling sentence on count 5 of 12 months in the county jail, and a controlling sentence on count 6 of 12 months in the county jail, all to run concurrently with each other. We would ask the court to confirm the 20% good time credit on the primary count, or primary offense rather, 12 months post-release supervision, that Mr. Parmenter be granted probation with community corrections for a period of 24 months. We would ask the court to confirm that he's entitled to 2 days jail credit. With regard to the conditions of probation, we have no objections to any of the conditions set forth in the pre-sentence investigation report, although we would ask that the no contact with victim be limited to the victim, Ricky Abbott, and that there not be a no contact provision with regard to Mr. Parmenter's wife, Patricia Lentz.
How much are your fees in the representation of this client?
Your Honor, I apologize. I did not get that number. I meant to, and then got distracted and didn't do it. If the court wants me to, I'm in my office, I could get that number in just one quick minute. I just have to run to my other office to get it. If the court, it would be willing to grant me a 1 quick minute to do that.
Why don't you run to the other office and get it?
I'll be right back, Your Honor.
And Your Honor, I believe Ricky Abbott is on actually with Patricia Lentz. Ricky Abbott is her brother. So when Josh gets back, if we could go back to Miss Lentz, I think Mr. Abbott wanted to speak as to the no contact order with him.
Okay, when I asked if there was anyone else, there was no response. So,
I understand, Your Honor. I just got a message from Miss Lentz after I made my recommendations. And apparently Mr. Abbott did not wish to speak, but I guess doesn't want the no contact order with himself to be continued. But I wanted the court to be able to hear from him directly.
Mr. Andrews, if you'd unmute yourself.
Yes, Your Honor.
How much are your
total
fees in the representation of the client?
They will be approximately $900 by the time the representation is complete.
What kind of work does your client do?
I work at Village Decorative Home and Remodeling.
What kind of money does he make at that job?
I make like $650 a week. I get paid weekly.
You obviously have dependents that you support, correct?
Yes, sir.
All right, Mr. Andrews, I don't know if you heard it or not. Ms. Norris had raised an issue, perhaps in your absence, about there was another victim who wished to address the court in relation to the sentencing, a Ricky Abbott.
I did catch the end of that, Your Honor, about the possibility of Mr. Abbott not wanting the no contact order either as a condition of probation, if I heard that right.
All right, well, if someone on the Patricia Lentz box wants to come on with audio and video, presumably Mr. Abbott, to address the court.
Hello.
Are you Ricky Abbott?
Yes, sir.
Okay, what's your statement?
So I didn't really like that you guys put words in my mouth. I didn't say that I didn't want the no contact order to be continued. I haven't really even spoken to anyone about that, or no one has spoken to me about that. And honestly, I would like to communicate with him, but I never once said for that to be continued, and I wouldn't like that for it to be continued.
All right, Mr. Abbott, I'm not going to try to defend the state's position other than to say, normally they're going to try to protect the victim unless they know differently. Okay,
Yes.
so if there was no communication between your office and theirs, they probably presupposed that you would want this protection.
Okay.
But
Well, I
don't
wouldn't
want-
like.
You don't want a restraining order, right?
No.
Okay. Anything else you want to say about this?
I think he's a good man, and he made a mistake. And if he works hard, I bet you he can come out through and be on top of the light in this. And if he tries his hardest, he might see God at the end. But that's all I got to say.
All right. Thank you for your statement, Mr. Abbott.
Thank you.
This time then, the court will address the defendant, Benjamin L. Parmenter III, and ask him if he has any statement that he wishes to make in mitigation of punishment here or anything further that he would like to present to the court. Mr. Parmenter?
No, sir. I just hope that I can go home soon.
The court will pronounce sentence in this case at this time. Court hereby establishes count 2 as the base sentence in this case for the offense of aggravated assault, a severity level 7, non-drug person felony, which the defendant has a criminal history score of C, thus placing him in grid box 7C. Court hereby sentences the defendant to a term of 27 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. Court has considered but declines to impose a fine on that particular count. For the additional offense of violation of a protection order, in count 4, a Class A misdemeanor, the court imposes 12 months in the Butler County Jail and runs that time concurrently with the time imposed on the felony count. No fine is imposed on that count. Regarding the additional offense of theft, a Class A misdemeanor in count 5, court imposes 12 months in the Butler County Jail. No fine, runs that time concurrently with the time imposed on the other 2 counts. The crime of domestic battery, a Class A misdemeanor, the court imposes 12 months in the Butler County Jail and runs that time concurrently with the time imposed on all other counts. Controlling sentence is a 27-month DOC sentence with the misdemeanor counts all run concurrently with that felony count. The time in this case will be run consecutively to Butler County case number 2024 CR 356. Court does find that in grid box 7C, this is a presumptive probation case under Kansas law. There does not appear to be a special rule application here. Therefore, this court will grant to the defendant an initial term of probation for a period of 24 months. Supervision will be by community corrections, since this is an offense severity level or higher. Conditions of that probation will include reporting to an officer as directed, the defendant observing all laws. The defendant is ordered not to possess or consume alcohol or illegal drugs while on probation. At a supervising officer's request and at his own expense, he shall submit to random breath, blood, and urinalysis testing. He shall perform community service work pursuant to any program requirements, gain and maintain employment successfully throughout his probationary term, notify his supervising officer of any changes in employment, residence, telephone number, or email address within 24 hours of any such change taking place. Court will not enter any no contact restrictions in this case. It appears it is the position of both victims in the case that they do not want the protection of any type of probation condition in this case. So peaceful and non-harassing contact between the defendant and these victim individuals will be allowed by the court. The defendant shall continue to register as an offender pursuant to the Kansas Offender Registration Act, abide by any curfew or travel restrictions imposed by his officer, and again, report is directed to his supervising officer in the case. Court will be assessing felony docket fee, felony probation fee, community corrections fee, a bids application fee of $100, and $450 in legal fees. Court does find that the court should consider the defendant's financial circumstances in lowering the amount of the overall attorney fees to be reimbursed to the state. The court does believe that the $450 amount, while less than the full amount, is appropriate under the circumstances, will not work a burden or hardship on the defendant or his dependents if allowed to be paid out over time. Department, I'm going to require you to pay a minimum of $100 a month on these obligations, starting with the calendar month of March. And
Did Judge Ricky freeze up on everyone or just me?
On everyone.
Okay.
Their faces. Priceless.
all right, Mandy, do I have audio and video restored?
Yes, Judge.
All right, and we are recording and broadcasting?
Yes.
Counsel, I regret any interruption of internet service that caused some delay in completing this sentencing. Ms. Norris, I know that you take meticulous notes of the sentencing proceedings. Where did the court leave off before service was interrupted?
Your Honor, you had set the minimum payment, reminded about registration. You had already noted the bids fees and that you wanted $450 in attorney's fees. And that's basically where we left off.
I did want to make clear, and I want to make sure that the defendant understands that he will be required to obtain an approved domestic violence offender assessment and abide by the recommendations of that assessment as part of his probation conditions in the case. Furthermore, the court does note the seriousness of this case with crimes of violence, including domestic battery included. This court will order the defendant as a condition of probation to serve 48 additional hours in the Butler County Jail effective immediately. As a condition of probation in the case. Mr. Parmenter, I know that you couldn't find the courthouse today when you were ordered to do so, but you will be required to find the Butler County Jail. If you don't know where that is, your attorney will give you direction as to how to get there. And you're going to have to report immediately to the Butler County Jail to serve 48 consecutive hours before being released on probation. You will need to contact your community corrections office upon release if you don't already have a probation date set. We can leave this meeting open for a conference between a community corrections officer and Mr. Parmenter if requested. Does the community corrections officer make that request?
No, Your Honor, we have an appointment set up for Wednesday at 4:30. So hopefully he'll be out of jail by then. If there is any delay, he just needs to call me whenever he gets out of jail and we'll reset his appointment.
Well, he should probably be out at the jail by 2 o'clock, so I don't see why 4:30 would be a problem. Thank you for that information, Ms. Stanfill.
Your Honor, I had a couple things I needed to address with the court. I would say that regarding the time he's going to be out there, he'd be leaving my office in Augusta. And so it may be, with it being 1:37 right now, maybe a little past 2 o'clock, but it shouldn't be much past 2 o'clock. I just say that because I know that if the jail believes that 2 o'clock p.m. is the check-in time and he shows up at 2:01, based on past experience, sometimes they will say, sorry, you didn't get here on time, and they won't allow him to start serving his time, which is what I want to avoid. But he would be leaving directly from here to the county jail. So whatever the drive time would be, usually for me, it's about 20 to 25 minutes from my office to the county jail. The second thing, Your Honor, is the court, it was noted in the pre-sentence investigation report that this was a registration offense case. At the time that we entered the plea, we did not specify that it was being a crime committed with a deadly weapon. So there was no duty to register notice made at that time. So my client has not made any type of, has not been notified of his duty to register, other than discussions I had before court in reviewing the pre-sentence investigation report with him of what that means.
All right. Does the state acknowledge that this is properly under Kansas law, a registration case, Ms. Norris?
Yes, Your Honor, based on count 2.
So noted, at least under the language of the amended information, it certainly was a crime committed with a deadly weapon, which would make this a registration offense. Mr. Smith?
Yes, Your Honor.
Has there been a notice of duty to register presented to Mr. Parmenter as part of the pre-sentence investigation process?
There has not, Your Honor.
So your recommendation as to how that should be handled?
Your Honor, if he would be willing to give the defendant a little more time to report to the jail, I can have that prepared by the time he got here and get a signature from him in that way.
Okay, so you would meet him out at the jail?
If he could stop by the office on his way to the jail to get his.
I see. Okay, I see what your recommendation is. All right, Mr. Parmenter?
Your Honor, I'm so sorry. I hate to try to force patience on this, but my client is wanting me to ask if it is at all possible for him to serve the 48 hours this weekend. He's concerned that if he goes in today, he's going to lose his job because he would be missing 2 days in the middle of the week.
Request is denied, Mr. Parmenter. I don't necessarily trust that you'll remember to show up this weekend. You didn't remember to come to court for this proceeding like you were specifically told to do.
I think that track record that you've established of not remembering what the court tells you speaks volumes. And I also believe that it's appropriate to carry out these sentences immediately and not deferred. So I'm going to order you to come by the Butler County Court Services office first on your way to the jail. This will defer your reporting time to the jail this afternoon. I'm going to expect you to be at the jail within 10 minutes of leaving the Court Services office. And I will order you to go directly to Butler County Court Services after we recess this court proceeding.
Ooh, Judge Ricky is not playing around.
So you go to Butler County Court Services at the Judicial Center first. Take care of your business with the notice of duty to register with Mr. Smith from Court Services, and then go directly to the Butler County Jail to serve 48 consecutive hours without release privileges. Mr. Parmenter, I'll just note that this court had authority to sentence you to up to 60 days in the county jail as a condition of probation. This court is elected to order 2. So I understand your position. I hope you're able to retain your job, maybe make a phone call to your employer on the way. And there are implications to criminal behavior, Mr. Parmenter, something you very definitely need to learn. All right. Ms. Norris, are there other sentencing related matters that we need to address before the court wraps this up with some of its normal admonishments?
I don't believe so, Your Honor.
Okay. Then, Mr. Parmenter, I will make sure the record reflects that you do have 2 days jail time credit for previous time served, which I'm not crediting against the 2 days of sanction time. These are independent of one another. But the sentencing journal entry should so reflect that previous jail time credit. I again will remind you, Mr. Parmenter, of your continuing duty to register as a violent offender under Kansas law. At some point in the future, you may have the right to seek expungement of these offenses. Certain statutory limitations do apply. If you have any questions about your right to someday seek expungement, you can address those questions to a lawyer and I'm sure get your questions answered. Mr. Parmenter, under certain circumstances, a criminal defendant may have the right to appeal a conviction to an appellate court having jurisdiction. If they are unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, Mr. Parmenter, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Ms. Norris, anything else come to mind that the court needs to address?
No, Your Honor. Thank you.
Mr. Andrews?
No, Your Honor.
All right. Any questions about what we've done here today, Mr. Parmenter?
No, sir.
Okay, well, you know what you need to do. Next stop, Butler County Court Services on your way to the jail. And I hope you're successful on this probation, Mr. Parmenter, and that I don't have to review your sentence in the future.
Your Honor, Ms. Stanfill actually just sent me a question wanting to know about his GPS and whether or not the court is ordering that as a condition of his probation, or I believe that was a bond condition.
He no longer has to wear a GPS monitor. That can be taken off immediately.
Thank you, Your Honor.
All right, then. If there's nothing further at this time, the Benjamin Parmenter matter will be in recess. This meeting may be ended for all at this time.
Thank you, Your Honor.
I hope you guys enjoyed that little FTC. Yeah. I assume that that other channels maybe got yesterday's hearing and have it, but here you get the whole story. You know, I kind of like when you get the whole story, or at least bigger portions of it.
This is in the District Court of Butler County, Kansas, case entitled Alternative Electric LLC Plaintiff versus Boeing U.S. Holdco Incorporated.
And this one, Mortimer Duke had sent me a link to it and said, here's a good one for you. I had already had it downloading, but I hadn't watched it yet. So I went with his word. So we all got to give Mortimer Duke a great big ol' hug and kiss for this one.
Jaeger Construction Group, LLC, and Hartford Fire Insurance Company defendants, case number 2024 CV 128. Beginning with plaintiff, would counsel announce their appearances for the record, please?
Your Honor, Eric Bruce on behalf of Alternative Electric.
May it please the court, Your Honor, Patrick Edwards, and I also have Marisol Garcia in the room with me on behalf of defendant Boeing U.S. Holdco.
Your Honor, can you hear me okay?
I can.
Oh, great. Thank you. I apologize for interrupting. Heather Shore on behalf of the surety.
And Your Honor, please court and counsel, defendant Jaeger Construction Group LLC appears through counsel Terry Malone.
All right. Counsel, this matter is scheduled to come before the court this morning for status conference. Court's just going to refer to its notes from our last conference on December the 12th of 2024. At that time, the court noted that Malone's extension to reply was granted to 12/27 of 24. Discovery deadline generally extended to February 15 of 2025. All reasonable efforts to be made to complete corporate representative depositions in January of 2025. Court ordered a mediation settlement conference with time, place, and manner to be determined by the parties, but to be before any trial date is set. And Mr. Edwards was to journalize that. And then the Zoom conference was set for today. All right, since then, the court notes from the file that there have been a number of motions that have been filed in this case. Have any of those motions been resolved? Mr. Bruce, let me ask you.
No, Your Honor.
Has there been any conferencing regarding any of the issues that are raised in these motions?
Yes, Your Honor. I've talked with Mr. Edwards a couple, 2 or 3 times. And our position is that we're available for depositions. We've provided all the documents that are appropriate and necessary for the matter, and we'll be available pretty much anytime with a couple exceptions. One is that my client is a master electrician, the only one with his company, and he needs to be there to keep his people on the job. So we've suggested that half days in the afternoon, he'd be available pretty much any time. We've also suggested that I've been told that we needed to produce payroll records. We've produced payroll records, but we haven't produced each payroll sheet for each employee, nor have we produced copies of the receipts for invoices for purchase of equipment that was used on the job. We don't think those are necessary for the determination of the matter, and we leave that to the discretion of the court.
All right.
Your Honor, I would like to respond to that on behalf of the surety. I have sent, I don't know, not less than 10 emails to Mr. Bruce after verbally having a discussion during the deposition, and he doesn't respond to me. Last I checked, my client's been sued, and I'm a defendant in this case, and so it's very hard to have a one-way conversation. So no, we've not resolved the issues because I cannot get Mr. Bruce to even have the courtesy of responding to me. I'm not asking for a lot. I'm just very confused about the documents and how they were produced. There were certificates of service stating that my office had received documents when we hadn't. And I don't need a lot in this case. I just am a very organized person, and it's been very difficult to manage the information in the way it's coming in. And then there just seems to be a lack of communication.
So last night it was the prosecutors that weren't communicating at all. And tonight it's the attorneys.
Mr. Bruce, can you address this communication issue?
I'll try. I think the problem is whether the communication is directed to me or to my secretary. And I think there's been some communication that's gone to my secretary that hasn't reached me. And as far as discussing matters with Ms. Shore, I'm ready to do that most any time.
Well, not according to her, Mr. Bruce.
I understand that. And I think that what's happened, like I said, is that she's been emailing Van, who's my secretary, and that hasn't been getting to me.
Ms. Shore, is that true?
No, I mean, you know, there's a lot of case law out there that says that we as lawyers cannot delegate duties to secretaries and then blame them. And I personally, you know, I don't know anything about that. I can just tell you that I'm emailing with an address that has his name on it. I've had other attorneys in this case email me independently and say, he doesn't seem to respond to you. Is he cutting us off, you know, from the responses? Would you share them with us? So I don't want to get in a situation where, you know, I'm questioning somebody's integrity or his secretary. I'm sure she's doing the best she can. The bottom line is we just need to be able to communicate with one another and respond to each other. And we're creating more fees and costs and time for the clients and the courts due to this lack of organization, lack of communication. It's not that, it doesn't need to be that big of a deal. I put in my motion exactly what I would like, and I just respectfully ask that the court order Mr. Bruce to take some time and respond to my request to get the certificates of service cleaned up, and then to please send me documents that he claims he has served on everybody. That's really all I need.
And I'd be glad to do that. And I will do that. And if you communicate with me through eBruce, that's the way to get me.
You have that email address, Ms. Shore?
Yes, Your Honor, that's the email that I have sent probably 6, 7, 8 emails to. Yes, correct.
Well, I just recall, you know, in ancient times when this court used to practice, we had something called a telephone. And I know it's an archaic thing, but you dial it and you actually talk to the lawyer on the other end. And I don't know if that's technology that's still available or not, but I might suggest that if it is, that you try doing that once in a while.
Your Honor,
I receive so many electronic messages in a day. Occasionally I miss one despite my diligence. That can be done, I think, by any busy attorney. So sometimes if you're not getting the response you want, I would highly suggest that you just pick up the phone and you call Eric and you let him know what the problem is so that he can address it. But Mr. Bruce, you've made some assurances that I think you're aware of what Heather wants and that you're going to promptly address those concerns. Is that correct?
As promptly as I can, Your Honor, let me note one thing. I'm out of town this week on the grandchildren mobile. I'll be back next week, and I'd be glad to, and I will send an email to Ms. Shore here shortly saying, please respond to me exactly what you need, and I'll try to have it to you next week.
And that's to his point, Your Honor. I'm kind of old fashioned too. I believe in picking up the phone, but that was a request he made of me when we spoke, was send me an email, let me know what it is you need. He was been, you know, very communicative at that point in time. It's just since then, when I send that email, so I'm happy to do it again. And if I don't get a response, I will call Mr. Bruce again. But I agree with you. I think that we do need to have a more personal touch. I'm trying to do what he's asking me to do. I just need to get a response.
All right. Well, I have every impression here that next week you will have that response.
Thank you, Your Honor.
All right.
Thank you, Mr. Bruce.
Thank you.
All right. I have before me a document entitled Boeing's Combined Motion to Compel Complete Document Production by Plaintiff to Extend Discovery Cutoff Deadline, to Extend Summary Judgment Response Deadline, and for award of attorney fees as sanctions, filed by Mr. Edwards.
Yes, Your Honor.
All right, when it comes to deadlines, that's something that is proper to address today. What is your suggested date for extension of a discovery cutoff deadline?
Your Honor, just because we needed to put a date in there in our motion, I believe we proposed June 13th of 2025. That is subject to us getting a complete document production from Mr. Bruce. I still don't believe, since we had our meet and confer, I need to double check my notes, but we had our meet and confer, I believe, on February 12th. I don't believe, again, I'm subject to me being wrong here on this. I don't believe we've received any additional documents from Mr. Bruce since we spoke. And we just need to close the loop on, our discovery response, or his discovery responses were out of time. So any objections were waived. I believe that all of our requests are completely proper anyway. There's a number of issues here that originally this was suggested by Mr. Bruce to the court that this is a really simple lawsuit. It's actually not. And I think his motion that he filed, or his response brief that he filed on, I don't have the date in front of me. I apologize. Actually, here I do.
24th.
Yeah, the 24th. I mean, I think it acknowledges that this is not actually a simple, straightforward case anymore. But there's a number of factual issues that we need fleshed out. One is whether the amounts that are being sought in these underlying mechanics liens that are the basis of this lawsuit now, whether they were approved by Jaeger as required under the contract, if they are outside the scope of the original contract amount. Another issue is whether they were that kind of came to light during the deposition that took place in early February, or the partial deposition because it hasn't been completed. Is whether the amounts were reasonable. Now there's a new issue as well that was brought up during that deposition. Mr. Bruce's client raised an issue of a industry practice, or at least I guess it started out as an industry practice, and now it may just be an alternative practice of you don't need written authorization if it's under $10,000. So there's now, I guess, there's a number of issues that this case is expounded and expanded quite a bit just following the partial deposition. And so we need to close the loop on the discovery requests and the responses that have been issued to date. And again, I hope that June 13th or whatever date we identified in our motion is workable. But again, a lot of that is outside of my control. We've got to finish up initial written discovery that for requests that we issued in August before we're able to move forward. Another issue that came up during the deposition was documents were produced both in the middle of the deposition. There was a break during the deposition for that to take place, and as well as the next few days after the deposition, there were additional documents produced. I don't have a whole lot of confidence that we've gotten, even ignoring the issues that Mr. Bruce raised about whether or not certain documents that we're requesting are relevant. I don't think that we have a complete production of everything else that's not in dispute, that there weren't objections to, just based on the way these documents have been produced in this case. So again, I'm trying to do my best. I'm trying to move this along. I'm certainly not trying to drag my feet on discovery or scheduling depositions, but we can't schedule any more depositions, including the completion of alternatives corporate rep, until we have everything, because at this point, it's just a waste of time if we keep going back every time something new is produced that should have been produced 5 months ago.
All right, we'll deal with this extension of the discovery cutoff deadline to June 13 of 2025 as proposed. Any objection to that extension, Mr. Malone?
No, Your Honor, we're joining in that request.
Ms. Shore?
No, Your Honor, same thing.
Mr. Bruce?
Your Honor, we have produced everything that we think that we have. During the deposition, my client was asked if he had additional emails or anything else. He was also asked about payroll records. He believes that he had previously produced those, but since he couldn't find them right away, He went ahead and we copied and provided those. Now, we have produced all we've got, with the exception, like I say, of additional per employee hourly payroll records. I mean, those could be produced, but I'm not sure that it matters. What we provided for is a spreadsheet that shows the number of hours worked by each employee on each date, and how much time they spent. In addition, the other thing that was requested was copies of the, what I will call, purchase receipts, because I'm using that phrase rather than invoices, because there's too many invoices in this case. And I don't want to get the court or the parties confused over that. The purchase receipts where we purchased items that were subsequently used in the project. We have not provided those. A lot of those came out of the warehouse. So, you know, if you have 25 widgets in your warehouse and you use 5, how do you provide a purchase receipt for 5 when you purchased, you know, the 25 that are in your warehouse over however much time? So I can't believe those items or that kind of information is necessary. My client has advised me repeatedly that most of the records that they think we produced at or right after the deposition were records that were included in the original set. Now, it seems to me that they're not wrong that we produced the records in spurts. And perhaps the best way to produce and to resolve this matter would be for us to have a deadline in 2 weeks that says, here is the set of records that we're willing to produce. All of them that we have. And that we be limited at trial to those records. That would move us down the road quickly. And we wouldn't then need to put off depositions or anything else. In addition, I would note that while we've been producing records, Yeager hasn't completed a lot of the email and other kinds of records, nor has there been any deposition of anybody from Yeager. What we believe is that the documents that have already been produced show that Boeing was invoiced by Yeager for the work that we did and was paid. Now they're saying that, well, maybe we shouldn't have been paid. But there is no question but that we didn't get paid ever on the matters that we're dealing with here. And just stretching things out doesn't seem like it helps a whole lot to anybody. That's all I've got, Ron.
All right. Do you have a reply argument to make here, Mr. Edwards?
Yes, I do. A couple things. First of all, the references to Yeager, I think that's entirely irrelevant. Terry and I have been communicating about those matters, and we're trying to work them out. And Mr. Bruce hasn't issued any discovery period in this lawsuit, so it's not related to any discovery that he issued. And again, we're trying to work through the matters with Terry, and I'm hopeful we might be able to. But that whole Yeager issue is a complete red herring. Mr. Bruce's comment that he proposes a deadline in 2 weeks for them to tell us that they've produced everything that, and I didn't take really good notes on what he said, but I think everything that they think is applicable in this lawsuit or something like that. It's not Mr. Bruce's decision on what's applicable and what's not. We issued discovery requests. He failed to respond in time. He waived any objections. Our discovery requests are reasonable and proper anyway. He needs to produce everything that's responsive to our requests. And our motion, or my motion on page 14 running into 15 has 5 Roman numerals is the things that we would like him to confirm. And that's not just that he's produced to us everything that his client has sent to him. That's only part of the story. I want Mr. Bruce to go through, because again, the way this is played out is I don't have a whole lot of confidence we've received everything. And I would like him to go sit down with his client, go request through request, and say, okay, here's what this request is asking for. Here's what it means. What have you done to try to compile documents that exist? What have you provided me? What else is there? Provide me with what's else. And then I just want written confirmation that all that's been done, because the piecemeal fashion of this, and the promises that have been made and then broken are just not, I mean, I don't have any confidence that we have what has been requested. And again, aside from the fact that Mr. Bruce waived any objections to our requests, our requests are proper. They relate to, if quite frankly, if you don't want to do discovery on this, then don't sue my client for $173,000. That's kind of you can't have it both ways. We're here now, so we're entitled to the documents, not just that Mr. Bruce thinks support his claim, but that are related to the work period. Because we're entitled to conduct discovery to try to poke holes in that if we disagree. And so I just ask that we get, again, a complete production of everything that is responsive, and then written assurance from Mr. Bruce as we request on page 14 going into page 15 of our motion.
All right, Mr. Bruce, you're familiar with these requests made on pages 14 and 15?
I need to look again at them, Your Honor, if I'm going to be claiming to be familiar.
Okay.
That's just the response. If he's talking about from the bottom of page 14 through page 15, I believe that we've done that. Other than the documents that I've indicated to the court today.
All right. The scheduling issue before the court was extension of the discovery cutoff deadline. I'll just note that production of requested documents in spurts necessarily causes delay.
Yeah.
The request for extension of time on the discovery deadline is not on its face unreasonable. Given the specifics of this case, the court is inclined to grant the extension requested to the date requested. Discovery cutoff is extended to June 13, 2025 for all parties. Court also noting that there's still some depositions to be completed and perhaps even noticed up for the first time that would be relevant to the issues of this lawsuit. Additional time is necessary to complete those. And I believe that the time frame suggested by this extension request is reasonable, and the court will grant it. June 13, 2025.
Your Honor, one additional issue that we may or may not need to deal with, but I just want to raise it for the court's attention. And I think Mr. Bruce and I disagree on this point, potentially. And Mr. Bruce, please correct me if I'm wrong. I'm certainly not trying to put words in your mouth there. But I believe that there are some expert issues now that are in play. And so I think Mr. Bruce disagrees with that. But to the extent, I guess, I'm just proposing to the court that perhaps we have, affirmative expert disclosure deadlines for Mr. Bruce, and then to the extent he discloses any, then rebuttal expert disclosure deadlines for the defendants. I'm not trying to create more work, but I do think that there are issues based on what the corporate representative testified to that are expert issues. And I'd like to know if, by X date, if Mr. Bruce doesn't have an expert, then we know, okay, forever and always, he's planning on proceeding without an expert, and we don't have, to the extent we need to file applicable motions, including that he doesn't have expert testimony designated that should have been, that is required for his claims. I think that would be useful and helpful. And I'm just trying to avoid a fight down the road and additional confusion. So I just wanted to throw out there that perhaps we do need expert disclosure deadlines just to kind of close the loop on those issues.
Expert testimony may be required as to what issues here, Mr. Edwards?
Well, one of his defenses, well, one thing, and this is probably quasi-expert testimony, but I always err on the side of having an expert if it's in that bucket, and that's certainly Mr. Bruce's up to him. But issues on whether or not work that is being sought in this lawsuit is within the original contract scope. Because again, if it's not, then there's another layer of the contractual requirement that has to be approved by Jaeger in advance in order to be billed. And so I think that whether something is or is not within the scope of work, for one, additionally, Mr. Bruce's witness testified at his deposition that I believe it started out as it's industry practice, but then it maybe morphed into it's his practice. That if it's under $10,000, you don't have to get additional authorization from your general contractor. Again, if it's to the extent that he's claiming something's industry practice, I think that would fall under expert testimony as well. Those are just a couple things off the top of my head.
Okay.
And again, if Mr. Bruce chooses not to designate an expert, then that's certainly his prerogative. But I would think it might be helpful to say, okay, we know he's made that decision by X date.
I don't have any problem with that.
All right. Initially, this court will establish a deadline for the plaintiff of 28 days from today's date to designate a proposed expert and provide a summary of anticipated testimony and opinions to opposing counsel. Mr. Edwards, how much time after that deadline passes should, of course, an expert be designated, or even if it isn't, for your own deadline for designation of experts and a summary of anticipated testimony and opinions?
Could we do, it looks like if we do 28 days from today, Your Honor, that puts it at March 31st. Could we have until May 9th, which is a Friday? Yeah, that's the Friday, the first full Friday, or first Friday of the first full week in March, or the Friday of the first full week, or sorry, in May. Good Lord, I'm sorry, Your Honor. May 9th, though, is what I was proposing.
Well, that's fine, Mr. Edwards, except that leaves only about a month of discovery deadline period remaining for the scheduling and conducting of that expert's deposition. So I would hope that that May 9th date doesn't cause again another request for extension of the discovery cutoff deadline. That's all. The court's initially going to grant that request. Defendants will have until May 9th to designate their own experts. And again, provide a summary of their anticipated testimony and opinions. So March 31 for plaintiff, May 9th for all defendants. Pertinent point, Mr. Edwards.
All right, I'm just trying to avoid fights down the road if we can.
Is the plaintiff still pursuing a motion for summary judgment, either partial or total, in regards to any defendant in the case?
Your Honor, our position is that documents show that the work that we did has been paid for by Boeing to Jaeger. And that in and of itself constitutes an acceptance of the work. And therefore, we think summary judgment is appropriate on the issue of whether the work was done.
Okay. So I think your answer is yes, you're still pursuing it.
Yes.
There were some procedural deficiencies pointed out, I think, in one or more responses, Mr. Bruce. And obviously that's not set for hearing today.
Right.
And I believe that there's actually a request to extend the response deadline. Are you still pursuing that, Mr. Edwards?
Yes, Your Honor. And I believe that both Heather and Terry have joined in that request as well.
Yes.
Your Honor, I've indicated that I had a willingness to do that if they could schedule up some depositions to get the thing closed out. That was my position all along.
All right. For the record here, Mr. Edwards, propose your new response deadline on the motion for summary judgment filed by Mr. Bruce.
Yes, Your Honor. We ask for 21 days after the last deposition transcript is prepared in discovery in this case. yeah, that's essentially our request, is that, you know, we're entitled to do discovery. I think there's a procedural deficiencies aside, I think there are a bunch of disputes of material fact here, genuine issues of material fact that, and that the loan, incomplete deposition has shown. And I think there's the more depositions we conduct, the more factual disputes are going to arise. So, yeah, we just asked to be able to complete discovery in this case and get back those, the last of the transcripts, and then respond to the summary judgment motion.
I trust Ms. Shore and Mr. Malone agree.
Your Honor, yes, I agree. I think that's appropriate because we were the ones that filed the response and pointed out procedural deficiencies, but we want to also address this on the merits if possible. So if we get the deposition transcript, we should be able to demonstrate to you what the disputes are versus just saying that there are disputes. I think you're going to want to see and identify what issues are in dispute.
Difficulty in that is establishing an uncertain date.
Your Honor, perhaps,
Go ahead.
I didn't mean to cut you off. I apologize.
No, go ahead.
With just to have a date down there, and I certainly understand Your Honor's concern there, should we set it at, I believe that the transcript from the incomplete deposition of Alternatives Corporate Rep was prepared maybe, I think we received it maybe a week ago, I believe, which was roughly 10 to 14 days after the deposition was completed. Should we just set, with June 13th as a new discovery cutoff deadline, should we just set the summary judgment response deadline for 30 days after that, knowing that it's going to probably take 7 to 14 days for a transcript of, if we wait until, or if assuming there might be some depositions towards the end of discovery, and that would hopefully give us enough time, and that would be ballpark of like either Friday, July 11th or Monday, July 14th. That's just a proposal, so we have a firm date.
Any comment from any of the other lawyers regarding that proposed date?
No, Your Honor.
No, you're wrong.
Feel like we need a firm date, Your Honor. Yes.
Monday, July 14th. Right. I think it would be premature to try to set up a hearing date on the motion for summary judgment. I don't want to lose track of this case, and I want to have another date on the calendar to address the status of this case at some appropriate time in the future. Counsel, I'm contemplating perhaps one just after the close of discovery on June the 13th. At that time, we would at least know, I think, a little bit more than we do now. And I think that we could, at that point, then schedule an appropriate date after summary judgment response period expires for the actual hearing of that motion. I'm going to look at a June date. Monday, June 16th, Counsel?
Your Honor, that works for Boeing.
Okay.
Your Honor, I am hopefully going to be in Spain on that day.
Okay, when will you be back?
Should be back on the 22nd.
Okay. This court goes on vacation a short time thereafter. Ms. Shore.
Are you going to be in Spain, Your Honor?
I will not.
Oh.
Regrettably, I will not, Ms. Shore. We government employees have limited resources.
Yes.
I hate to put something in there. I was looking around that July 4th holiday. Probably looking at Tuesday, July 8th, Counsel. Tuesday, July 8th.
That works for Boeing, Your Honor.
We'll do 11 o'clock a.m. again.
Certainly, Your Honor.
Your Honor, I can
Standard
make that
conference
work.
in
That's
case.
great. Right.
And I'm going to look and see if there's any other issue that needs to be addressed today. Mr. Edwards, let me ask you first.
Your Honor, the only two other issues from our motion are, and I think we kind of touched on this, but I don't know if we fleshed out entirely, is the motion to compel complete discovery responses. We just request, kind of like what I mentioned earlier, that Mr. Bruce sit down with his client and go through the Roman numerals 1 through 5 from pages 14 and 15 of my motion, and either produce what has to be produced to satisfy those Roman numerals, again, which it includes all responsive documents, not just documents that he intends to use to support his claims. And then confirming in writing each of those issues, which are that he met with his client to talk about them, discussed each request in interrogatory with his client, that his client has searched for and compiled all responsive documents, communications, and information, that all of that has been provided by his client to him, that he's then produced everything to us, and that if he's withholding anything, he provides a privilege log or otherwise spells out what it is that he's withholding, so we know it exists.
All right. I think on its face, that's a reasonable request, but I do want to allow Mr. Bruce sufficient time to accomplish that goal.
Yes, Your
And
Honor.
hopefully completely and for all purposes, those issues would then be resolved. I'm thinking about a month to do that, Mr. Bruce. Is that a realistic time frame?
Yes, Your Honor.
All right.
Okay, so just to make sure we're all on the same page, if we have a month then to do that, then is that going to put us in a pickle to try to squeeze, the rest of the discovery into a very compacted period of time? I just want to make sure everybody's realistic about our schedules.
It's 2.5 months remaining in the discovery period after that deadline.
Okay. Well, hopefully that should work.
All right, Mr. Bruce, your deadline is
Am I back? Am I back? Everything froze. My internet connection dropped. Everything froze. Okay. I think we're good. I think we're good. I'm sorry. I'm sorry. I'm sorry. All of a sudden I got a black screen. Yeah, well, I've got it open over there because gotta keep my eye on stuff. No. All right, I'm gonna go back just a couple of seconds. Yeah, it's paused, Eileen. Yeah, I got it paused. Give me 1 second. Okay, so 47:49. So it's so hard to go just a couple of seconds with this dang cursor. All right, I went back about 1 minute.
completely and for all purposes, those issues would then be resolved. I'm thinking about a month to do that, Mr. Bruce. Is that a realistic time frame?
Yes, Your Honor.
All right.
Okay, so just to make sure we're all on the same page, if we have a month then to do that, then is that going to put us in a pickle to try to squeeze, the rest of the discovery into a very compacted period of time? I just want to make sure everybody's realistic about our schedules.
It's 2.5 months remaining in the discovery period after that deadline.
Okay. Well, hopefully that should work.
All right, Mr. Bruce, your deadline is ordered by the court to be Friday, April 4. Friday, April 4. And then at that point, the documents to be produced should be complete as far as discovery and turnover of those documents. Everyone should know exactly what the documentary record of this case is from the plaintiff's perspective, and then further scheduling can be accomplished from there.
And Your Honor, just to be real clear, just so there's no confusion here, that would be for all responsive documents, correct?
Correct.
Okay. Thank you, Your Honor.
Your Honor, the only thing that might be an issue would be the expert, but I think we're going to get that in 28 days. So that should be workable.
All right. Very well. And Mr. Edwards, once again, I'm going to be tasking you with drafting an order stemming from today's proceedings, documenting the matters that have been covered by the court.
That sounds good, Your Honor. The only outstanding issue then, I think, with the motion compel issue is we had the last request for fees. I just wanted to raise that for the court just so we could, to the extent the court is so inclined.
I note your request, and I read that in your motion, Mr. Edwards. The court will take that issue under advisement at this time. I want Mr. Bruce to have an incentive here to fully comply with the requests made without sanctions. I really would just want to see voluntary compliance with discovery requests, which Mr. Bruce has unequivocally pledged. And the court will take I'm not going to deny your request at this time, Mr. Edwards, but take that under advisement at this time for later ruling.
Understood, Your Honor. Thank you.
All right. I think we've got Mr. Edwards' matters covered. Ms. Shore, is there anything else that we need to address today?
No, Your Honor. Thank you very much.
Have a good time in Spain.
Thank you.
Mr. Malone, anything further we need to address today, sir?
Your Honor, one thing, I've been sitting here listening to all of the issues about the discovery. One of the things that came up in the corporate rep deposition of Mr. Bruce's client was that towards the end of the deposition, he testified that at some point he had taken all of the unpaid invoices that were initially issued to my client and had them all reissued in Boeing's name. And I've yet to see any of those invoices. So when Mr. Bruce is looking for documents that his client says existed and were going to be produced, that might be something he might note.
That's a fair request, Mr. Malone. Mr. Bruce, anything you want to say about that?
I discussed that with my client, Your Honor, and I think the invoices that he's talking about were sent to Boeing, but I don't know that they were printed out in Boeing's name. I will verify again whether that is so.
Well, he testified that they were at Boeing's request. So I don't know what he did, but that was what the testimony was.
You understand?
Okay. And Mr. Bruce will respond appropriately to that.
We will, Your Honor. Sometimes there's a good reason for a read and sign on a deposition.
Indeed. All right. I think the issues that need to be addressed today have been, counsel. Again, Mr. Edwards, if you'll journalize the matters that have been covered today, including the specific deadlines that have been established. Good luck, counsel, in working together to try to resolve all issues in the case, discovery or otherwise.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Very well. And if there's nothing further at this time, this matter will currently be in recess and the meeting may be ended for all. Have a good day, counsel.
Thank
Thank
you.
you, Your Honor.
Court calls the matter of people of the state of Michigan versus Christopher James Dennis Kamen. This is file 24-5335 page.
You're welcome, yes, the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Christopher Kamen.
Thank you, sir. Are you Christopher James Dennis Kamen?
Yes, sir.
Mr. Kamen, we're here today for a status conference and a plea cutoff. We have a trial for your benefit set right now on April 30th and May 1st. You're aware of that background, correct?
Yes, sir.
And have you maintained good contact with your attorney since the last time we were in court in about December of 2024?
Yes, sir.
Mr. Thompson, what can you tell me regarding the readiness of this case for trial and how we should otherwise be proceeding?
Well, Your Honor, I have spent a lot of time with Mr. Kamen the past week. He's been seriously considering the plea offer, which is an offer to an attempt. He's charged with a 5-year felony, possession of a firearm by a felon. The offer would be a attempt to make it a 2.5-year. I just asked the court to ask Mr. Kamen about his intentions.
First, is that an accurate statement of the plea offer, Ms. Coe?
It is, Your Honor.
Mr. Kamen, were you aware of the terms of that plea offer?
Yes, sir. Mr. Thompson explained most of the conditions to me.
And so is it fair for me to understand that you're aware of the benefits of the plea as well as the risks of the plea?
I'm not, well, yeah, pretty much, because the risks of the plea will be to, max sentence, correct?
Well, under the plea agreement, right now you're charged with possessing a firearm while you were prohibited to do so because of a prior felony conviction. That means it's a felony that has a maximum of up to 5 years in the state prison system. But if you plead guilty under the plea offer to an attempt by law cuts the maximum penalty in half. Then the maximum penalty would be 2.5 years maximum that you could ever face. You understand that benefit of the plea agreement?
Yes, sir.
And did you have time to talk about it with Mr. Thompson?
Yeah, shortly, but enough.
All right. And so we have a trial set for you on April 30th and May 1st. And as I explained to you previously, what I do when I set a trial is also set a plea cutoff in advance of trial. And the reason I do that is I don't want to keep cases on for trial if we don't need them. If we need a trial, then you'll have it. You have a constitutional right to a jury trial. So the question becomes at a final status conference and plea cutoff, whether or not you want to keep the trial on so the jury can determine the issues, or whether or not you want to take advantage of the plea offer. And it does not matter to me what you do. I just need to know what you're deciding so that I can schedule appropriately. So which option would you want to have? Did you want to take advantage of a plea offer, or did you want to have a jury determine the case?
At this moment in time, with me being able to think about it, I'm pretty confident in just accepting the plea.
In other words, you don't want to have a trial and you prefer to take advantage of the plea offer that's been stated on the record today. Is that right?
Yes, sir.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, sir.
So again, Mr. Kamen, under this plea agreement, you're going to be pleading guilty to the offense of attempted possession of a firearm by a felon. Do you understand that?
Yes, sir.
And the prosecutor would then dismiss the charged offense. That makes it a 2.5 year maximum offense instead of the originally charged 5-year maximum. Do you understand that?
Yes, sir.
If you're convicted of the attempt, the law also requires mandatory forfeiture of the weapon or device. Do you understand that?
Yes, sir.
And understanding the benefit of the plea agreement as well as the maximum penalty associated with that plea, then how do you plead to the attempt?
Guilty, I believe.
If you plead guilty, did you have a question about your plea, Mr. Kamen?
No, my brain's been jambled with this whole case and everything going on lately between the
That's
move
all right.
and
I'll try to
everything.
go through it slowly. If you have questions about the procedure during, you can let me know, raise your hand, get my attention, and we'll make sure we go through it so that you understand. You need to understand that if you enter a guilty plea, you no longer will have any automatic right to appeal. If you're convicted following a jury trial, you have an automatic right to appeal. But if you're convicted by a plea, you have limited appeal rights. You would have to instead ask for what's called leave to appeal to the Michigan Court of Appeals. Do you understand that?
Yes, sir.
If you plead guilty, you lose all of your current trial rights, including the right to trial itself on April 30th and May 1st. Those rights include the right to be tried by a jury of your peers, the right to be presumed innocent until you're proven guilty, and the right to have the prosecutor bear the burden of proving your guilt beyond a reasonable doubt. At your trial, you'd have a right to have each of the witnesses against you, and you would have the ability to see, hear, and question them. And you would have the right to have the court order any witnesses on your behalf to be ordered to appear at trial. You'd have the right to remain silent at your trial and not have that silence used against you, and you would have the right to testify at trial if you wanted to. But if you enter a guilty plea, you lose those trial rights. Do you understand?
Yes, sir.
And because you're giving up your right to trial itself, you also necessarily give up the right to challenge other things that you might have been able to challenge if you did have a trial. Do you understand that?
Yes, sir.
Outside of the plea agreement, has anyone promised you anything to get you to plead guilty?
No, sir.
Has anyone threatened you in any way to make you feel like you have to plead guilty?
No, sir.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And is it your own choice to plead guilty?
Yes, sir.
The prosecutor claims the offense happened on or about January 12th of 2024. So were you present here in Crawford County on January 12th of 2024?
Yeah, in Crawford County, yes, sir.
All right, and prior to that date, had you been convicted of a felony offense of controlled substance delivery or manufacture of a Schedule 1, 2, or 3 controlled substance?
Yes, sir. My prior charge is the reason why I have the other felony.
Your what?
Is that for the prior charge, the other felony that I have?
Right. Did you have a felony on your record as of January 12th of 2024?
Yes, sir.
And when was that felony committed, and when was it placed on your record?
I believe in 2019 or 2020.
And then after the conviction in 2019 or 2020 for that felony offense, do you agree you did not take the actions that you needed to regain your ability to possess a weapon here in Michigan?
Yes, I believe so.
And then on January 12th of 2024, and while you were here in Crawford County, did you possess a weapon?
I didn't possess. It was attempted, pretty much, per se.
Well, how do you per se attempt to possess a weapon? And when I say weapon, I mean firearm. How did you attempt to per se possess a weapon?
It was offered to me by somebody at the time, and I turned it down because I knew I had a felony.
So it doesn't sound like you attempted to do anything. It sounds like you attempted to not do anything.
What do you mean by that?
Well, you just told me you turned down a request of somebody to have you get a firearm.
No, that's where it's all misleading. I was not in possession of any sort of firearm.
How would I find you guilty of that attempted offense?
What's that?
Then how would I find you guilty of that attempted offense if you're telling me you're not guilty of it?
Because attempted means that it was attempted. That doesn't mean that it was actually followed through with. It's just an attempt.
This is not a complicated process. If you tell me you're guilty of an attempted crime, you have to tell me that you're guilty of an attempted crime. If you tell me that you're not guilty, that's the reason why we have jury trials, if we need them, because a jury will determine whether, based upon the evidence presented by each side, whether they believe you're guilty. But if you're telling me that you're not guilty, then I'm not going to accept the plea from you.
Okay, well, then at this point, I'm guilty of it.
Well, how are you guilty?
Because there was a firearm involved that I knew about, and it was attempted to be in my possession, I guess.
Where was the firearm at?
It was through somebody. It was through a job that I had done work for people for.
Did you physically have possession of the firearm?
No, sir. I had photos.
I'll know some limited questions by you, but as you can probably sense, this process is not going the way that a plea ought to go, in my estimation. So if you have some additional questions you can ask of your client that might get to a factual basis, I'll allow it. Otherwise, I'm inclined to just keep the trial on and have the jury determine whether or not there's evidence sufficient to convict or not. So did you have questions for your client?
Mr. Kamen, did you do anything to attempt to possess a firearm?
Not willingly. It was being offered to me, and I declined it.
I would agree with the court, Your Honor. This matter should be set for trial.
All right, Mr. Kamen, I reject your plea or your attempt to enter a plea. This matter is best resolved by a jury, and so I'm going to keep the jury trial on. Your jury trial is set for April 30th and May 1st of 2025. Just go based on the number of witnesses you're going to call, and you still believe you're going to be 2 days.
I mean, how come I can't accept the plea right now?
You can't accept a plea when you tell me you're not guilty, Mr. Kamen. That's not how this process works.
He looks scared to death.
Well, I'm telling you, I'm guilty of it. I did try to acquire it. That's why I'm trying to accept this plea.
Can I ask him a question, Your Honor?
That's not what you told me, Mr. Kamen. This isn't a funny situation, but I laugh in part because it's frustrating to me that as we get past the time when you've told me multiple times that you're not guilty, that now you're telling me you want to enter a plea. That's frustrating to me because this is not, again, a complicated process, and it's one that you've known about for months leading up to today. Ms. Koch, you can ask a question if you think you might get to a factual basis.
Mr. Kamen, you messaged a person named Joe Smith who sent you a photo of a gun and you wrote back, yo, how much? I want that for myself. I got pounds of good green. I can trade. Just let me know. Did you say that?
No, I never once said that.
Okay. Were you trying to purchase that gun from somebody?
No, if the facts are straight, it was trying to be given to me for money that was owed.
The matter is going to be set for trial. If parties can attend. Ms. Koch, do you think a day is enough, or do you think it would be safe I should keep 2 days?
I think we can do it in a day.
I have two potential witnesses at this time, Your Honor. I'm not committing to calling either one, that I would think would take, within 2 hours, just in terms of trial scheduling.
Well, you know the case that the prosecutor's at least going to levy. Do you think the prosecutor's witnesses that you think she's going to call and your witnesses can get that in a day?
That would be my prediction, yes.
Well, I'm going to keep the trial date on for April 30th. May 1st is already set aside as a trial date, so we'll use it if we need it. We'll not use it if we don't, but it'll be on if we need it as a backup date. Mr. Kamen, my requirement for you and for your attorney is that each of you are here and ready to proceed to trial no later than 8:30 on the morning of that trial. That's April 30th. That's here in the circuit courtroom for Crawford County. It's an in-person proceeding, of course. Do you have any questions about that?
No, sir.
Ms. Koch, you otherwise ready to proceed to trial, or anything else the court needs to be aware of?
No, we're ready to proceed.
Mr. Thompson,
No, nothing further.
we'll see you on your morning of trial, Mr. Kamen. Thank you.
Yep.
If that wasn't his text message, then yeah, it needs to go to trial. If that was his text message, yeah, he needs to go to jail. I mean,
All right, we're going to call next matter of the State of Michigan versus Darrell Wayne Curtis Jr. This is file number 24-5353FC.
Sierra Coke on behalf of the people.
Thank you, Honorable Ravi Murthy, on behalf of Mr. Curtis.
Thank you.
And
In
Your
the
Honor,
Roscommon County Jail, sir, you Darrell Wayne Curtis Jr.
yes, sir.
Mr. Germer, did you have something you needed to cover?
I did, Judge, and Mr. Shiloh Engel should be in the courtroom as well. I just wanted to make sure that he was present in the courtroom for this hearing.
Or if you could stand up so that the attorney and Mr. Curtis can hear that you're here.
Your Honor, yes, I'm observing today these proceedings.
And your name?
Tyler Engel, P75720.
So are you somehow involved with this case?
I've been asked to basically offer a consultation to the defendant.
Well, so you have not filed an appearance.
That's correct.
And you, at least at this point, don't know whether or not you're going to file an appearance.
That's correct.
So you're of course welcome, like anyone is, to view the proceedings today, but for obvious reasons, I'm not going to hear from you. Mr. Curtis hasn't retained you. If he retains you, I'll certainly hear from you, but not until, and I think that's probably fairly obvious to you, but you're welcome to observe. Mr. Curtis, have you had enough time to talk with your attorney, Mr. Germurthy, about this case?
I have not, sir. I need to talk to him more about the case.
Why have you not talked to him about the case prior to today's hearing?
I have contacted him, he's contacted me, and then I got put in here 2 weeks ago, and this case is being dismissed tomorrow. I just haven't had time to respond back with him since then.
Mr. Curtis, this case was bound over to my courtroom, to the circuit courtroom back in November of 2024. So coming up on 4 months ago, you've only been in the Roscommon County Jail, you said, a couple of weeks, right?
Yes, sir. I was in Crawford County Jail prior to that on bond violation for a picture.
I'm aware of that. I'm the one who signed the order remanding you to jail for those bond violations. During all the time you were in the Crawford County Jail, you're telling me you didn't have enough time to talk to your attorney?
I did not talk to him, except for on the phone there. If I can clarify, the last 2 weeks when he was in the Roscommon Jail is where we haven't had contact. But prior to that, Mr. Curtis and I did have contact. Mr. Curtis has provided me with the necessary witnesses and statements and things and photographs that I've requested. So there was contact prior to that. And then I've maintained contact with his mother, who has provided necessary information for me as well. And then as of Friday so 3 days ago, excuse me, Mr. Curtis's mother indicated to me that they were going to seek a second opinion from Mr. Engels. And I simply wanted to have Mr. Engels identify, so Mr. Curtis knew that Mr. Engels did come up here and intends to meet with him after the court hearing today to go over the second opinion that Mr. Curtis intends to have.
Well, let me ask you this way then, Mr. Dermurthy, because if it's one that your client rather, is asking for more time to meet with an alternative attorney, I have to look at that and decide whether or not that provides good cause to adjourn the jury trial that's currently set. Is that what you're telling me? Is that you think it provides good cause to adjourn the trial that's set?
No, I don't think. In speaking with Mr. Engels, I think he would be ready to go to trial as well, which is set at the end of April and the first day of May. So I don't think we're asking for an adjournment for the trial. And I would be ready for the trial as well, that is already set. So what I'm simply letting the court know is Mr. Curtis and I are ready. We would be ready between now and April, because my understanding is he does get out tomorrow. So we're not asking for an adjournment. I believe there'll be plenty of time. And I've discussed this case at length with Mr. Engels as well. So based on that discussions, I think Mr. Engels, if he were to substitute in, would also be ready.
And so you're telling me, in other words, that the plea cutoff, which was set for today, is going to be rejected, and there is going to need to be a trial in this case. Is that more accurately what you're telling me?
That is correct, unless something changes between the conversation Mr. Curtis and Mr. Engels have, which certainly they haven't had.
Mr. Curtis, is that accurate? You wish to deny any plea agreements and have a jury determine the issues in this case?
Is it still the same plea? No.
Ms. Cope, for the record, could you tell me what the plea offer was?
The offer was possession with intent to deliver. The offer was made on October 8th. So just shy of 5 months, or around 5 months ago. We are prepared for trial.
So can you tell me then, the offer being that, what would you be dismissing in terms of the plea offer?
The carrying concealed weapon, the habitual fourth notice, the DWLS, and the DWLS second enhancement. And I think there's a possession charge as well at the end of it, all of those.
All right, so Mr. Curtis, was that the plea offer that you were aware of?
There was no possession. It was a delivery. I was charged with delivery, weapons charge, and driving unsuspended and probation violation. And I thought it was offered for me to drop everything to a delivery. I didn't know it was a possession. What would be the what would my guidelines pertain to for that possession with intent? I don't know.
So guidelines, Mr. Curtis, as you've heard so far today, but let me clarify, aren't part of the inquiry here. They might be important to you, but they're not part of the inquiry for this reason. Guidelines are scored by the court, not by the attorneys. So the attorneys are the ones who are negotiating this potential plea offer. But the attorneys aren't the ones who ultimately score the guidelines. I am. That's why guidelines ranges in about 99% of the cases have nothing to do with the plea. The only exception to that is the attorneys at some points would approach me and ask me to agree with them or disagree on a guidelines range. That's called a sentencing agreement. The attorneys haven't approached me about that, and I'm not willing to engage in a sentencing agreement because they haven't provided me that information. So the plea agreement would be as if you plead guilty to the possession with intent to deliver methamphetamine. The prosecutor would dismiss the carrying concealed weapon, the driving while license suspended, and the habitual offender fourth offense notice. Do you now understand that plea agreement?
I do understand now, sir.
And the plea scope, was there something additional?
Your Honor, on December 10th, we did do an amended felony information that included the labs for possession of fentanyl. So that was the fourth count. And I think Mr. Curtis is misunderstanding something. I just want to clear it up because I heard it. I don't know if the court heard it. The offer was possession with intent to deliver, which is under the same statute as delivery. The offer was not straight possession. Your Honor said it correctly. Mr. Curtis did not.
And that is what I've advised Mr. Curtis as well, that it's a 20-year B grid, B for Bravo, B grid felony. It's not a D grid possession 10-year felony. that it is, and then we went over this at the last court hearing as well, Judge. I think the court apprised Mr. Curtis of the tail end, which would be a life offense, and all the other charges. And Mr. Curtis rejected that, and as of now, my understanding is he's still rejecting this offer. So I want to make sure that he's clear that it's not a possession of methamphetamine. It is a possession with intent to deliver methamphetamine, a 20-year felony.
Are you clear about that plea offer, Mr. Curtis?
Yes, sir, I am.
And did you wish to take advantage of the plea offer or reject it?
I wish to reject it, sir.
You understand if you're convicted at trial as a habitual offender fourth offense notice, the maximum penalty is life?
Yes, sir.
And you wish to reject the potential plea offer, understanding fully the maximum penalties that are instigated if you're convicted at trial?
Yes, sir.
So the court will keep the trial on. However, as the attorney that was here in the courtroom heard, and Mr. Gurmurthy, I don't think you were in my hearing room yet, I have a different trial which has a predated case number on the same date. This trial will therefore not take place on April 30th and May 1st, but I'm going to set it at my next available date, which will be very soon. The April 30th and May 1st date is set for a different case, which is set on the same days. This case will have a standalone trial date. It will be set at my next available date, but this one will be the case that will go, meaning it will not get bumped or moved in any other case because Mr. Curtis is and will remain, at least until I order otherwise, lodged in Crawford County. So I'm going to set it as soon as I possibly can. Ms. Koch, is there any specific time period that the people need, or are you ready to proceed as soon as I can set it?
We're ready to proceed.
And Mr. Gurmurthy, same question for you. You said you're ready on April 30th. Does that mean obviously you're going to be ready to proceed to trial as soon as thereafter I can set any date?
Correct. I have all the requirements of the evidence that Mr. Curtis for his defense wanted to provide me. I have those. And if anything else comes along the way, we'll just supplement those, but we're ready.
All right. Mr. Curtis, we'll see you on your morning of trial. If to the extent I issue an order later that affects your bond, you need to be aware that the requirement is you're here and your attorney's here in the courtroom no later than 8:30 on the morning of trial. Have you yet made arrangements with Mr. Gurmurthy for proper clothing for trial?
I was to the understanding that I was still on bond for that case, and this case is being dismissed tomorrow.
You have not had a bond. I have revoked your bond. I remanded you to jail, and so there is no bond that was in place. Am I misunderstanding something, Mr. Gurmurthy?
At the last hearing, we had a new bond that was set for Mr. Curtis. He posted that bond. And then
I didn't recall that, and was, or I'm glad I'm having the attorneys refresh my memory. Mr. Curtis did post a bond after I set a new bond. Ms. Koch, are you aware of that?
I don't generally know when they post them, but Your Honor did set a bond for cash or surety at $20,000 on 1/21/25.
To the extent, Mr. Curtis, that you've posted a bond, and I don't see that information, but that's fine. If you posted a bond after I said it, that bond will continue unless and until I'm given information to suggest that it shouldn't continue. I was apprised of my memory, and apparently I set a bond, and apparently you have posted it. Again, unless I change that order, you'll be either remanded if I didn't issue the bond, or if you posted that new bond, you'll be subject to all the conditions in that new bond. Ms. Medler, do you have a copy? I just gave you the court file back. You have a copy of that updated bond. You have a copy of your system.
That there is an open bond, but then no, he did post through Craig's on 21.
Okay, so you're still on that bond then, Mr. Curtis, assuming that everything's dismissed from Roscommon County, you're not held anywhere else in the state. So we'll see you at your trial date. You'll get a notice in the mail for it. Let me have your address again, so I make sure and send your notice to appear at the right address.
It is 751 Grading, Michigan.
Thank you. Is that what you had?
Yes.
All right, we'll get the notice for the new trial date to your address, Mr. Curtis, and to each of the attorneys. Do each of you still believe that the 2-day trial is warranted and necessary? Still.
I think that I'm going to be done in one day, but I think your defense brings in several witnesses. We're going to need the second day. I don't know that we're going to know that until the trial.
Mr. Gurmurthy, do you think having a 2-day trial is a safer bet if you're going to call witnesses?
it is, Judge. So far, we've identified about 3 witnesses that we intend to call. So given those 3 witnesses, albeit they might be short, I think we might be better off going into a day 2 so that we have ample time to present the defense's case. I also want to say for the record, Judge, at the last hearing, we did indicate that Mr. Curtis could raise a defense of a lesser included of possession of methamphetamine. And I think the court indicated that we did not have to file a separate notice or a motion for the lesser included because we did apprise the prosecution and the court of that.
Well, because the prosecutor stipulated, that's correct.
Yes.
Right, let's go.
Yes.
Right. So you don't need a motion for it.
Okay.
Thank you. Stipulation of the prosecutor. So I'll expect jury instructions no later than 14 days before trial, and we'll get this matter set. Thank you, Mr. Curtis.
Thank you. Have a good day. Thank you, Robbie.
I also had Holly Harris that I'm going to bring in. My understanding is Holly Harris was a person who suggested some form of treatment or counseling. I received letters that I'm sure the attorneys had and covered that as well. We're on the record in the matter of People versus Laura Ann Kenny. This is file 24-5355 FH.
Sierra Coke on behalf of the people.
And thank you, Honorable Governor, on behalf of Ms. Kinney.
Thank you. And ma'am, are you Laura Ann Kenny?
Yes, I am, sir.
Ms. Kenny, we're here for a status conference today. Have you had enough time to talk with your attorney about what you want to do today?
Yes, I did.
Mr. Murphy, did you have a suggested course of how the court should proceed today?
Yes, Your Honor. Your Honor, excuse me, Ms. Coke's office indicated and tendered us a plea in this matter to count one, attempt false report of a felony. So that would be an added count. The habitual second offender notice would be dismissed. And Ms. Kinney would be pleading no contest to that attempt charge due to lack of memory.
This case gets wild. I am not kidding you.
And I did provide the court with a copy of the police report to review for taking of a no contest plea.
Is that accurate, Ms. Coke, that the plea is for an attempt dismissal of the charged offense in the habitual second?
Yes.
Do the people have an opposition to a no contest plea?
No,
Do you think the lack of memory would be an appropriate basis?
it is.
The court would note then in advance of the hearing, I was provided a police report, which I reviewed in full. The police report does not convince the court that there's proof to accept the plea, and so I will not accept it on a no contest theory. The court doesn't have any issue with no contest pleas, but I've explained this several times to the attorneys, but perhaps I need to explain it again. When I have a case, and this is a significant case, it's an allegation of false report of rape, of criminal sexual conduct. And when I have that, and I have clear indicia of guilt, I will and have no issue accepting a no contest plea if I find it to be appropriately established. But where, in this case, and in other cases that have been recently submitted to me, I have clear indications from the defendant in a police report that they're denying any wrongdoing, I'm not going to make findings of guilt or make a determination whether or not the denial is believable or not. That's a jury's function, not a court's function. I will not accept pleas where defendants tell me they're not guilty, and I will not accept no contest pleas where the evidence clearly doesn't preponderate that there's any type of criminal activity. In this case, Ms. Kenny, according to the police report, the summary of the facts is that she reported that she was violently raped by two individuals. She reported then that that happened and repeatedly reported that to police, that she was violently raped. Other information suggests that the other individuals were interviewed and denied violently raping her or raping her in any way. And they consented to, at least one of the individuals consented to a DNA test. And there was some other clothing brought up and tested. No other indication of guilt is indicated anywhere in the police report. And I won't suppose that that's the case under a theory of a no contest plea. I simply don't find the interest of justice to be served by that. So, Mr. Germer, I will not accept a no contest plea for those reasons, not because of the no contest plea itself, but because of the lack of facts that convinced me of guilt from the police report. Did you have something else I should consider other than the police report you've offered so far?
No, Judge.
Ms. Coke, is there something else I should consider outside of the police report that's been shown so far?
No, we'll be prepared for trial then.
Do you believe that the police report establishes guilt, Ms. Coke?
Well, I charged it based on what I read in the police report, which was her statements that were not corroborated in any way by any of the evidence. And frankly, all of the evidence corroborated the opposite.
Is
But
there more evidence other than the police report? Did you talk with, for example, Detective Sergeant Clavadlo?
well, I talked to the officers. We've talked to the victim, or the victim that she said raped her.
So more information is known to your office when you charge the offense than is provided in the police report.
Yeah, I suspect, yes.
And so your belief is that there's guilt, but I'm asking a different question. I know that it's difficult maybe for you to separate them from the police report. where a defendant says that she was violently raped and where no statements contrary to that are there, how would I find guilt?
And I think that when I looked at the police report, there's a recorded conversation that it states it in there, but it doesn't state what it said. So I think I probably had significant more information when I charged it. So I understand we can be prepared for trial and we will go forward that way.
Mr. Gurmurthy, how from the police report you submitted to me would the court find guilt? What am I missing?
The statements made by Ms. Kinney would, again, I would echo Ms. Koch's sentiments that they were not then corroborated with the interviews with the other individuals, plus the lack of memory that Ms. Kinney had at the time when she made those statements.
Well, look, counsel, lack of corroboration, as the attorneys well know, is not it's not an element. If her statements are that she was raped and a jury were to believe her, that's enough for a conviction.
And on supplement too, she specifically says Laura made statements that she did not think the men raped her. Laura made statements that she was having a flashback from a previous sexual assault from another person. Laura made statements about wanting to make sure the case was dropped against the two men.
There is a supplement because unless I missed it, I didn't get a supplement. I got a single police report that has, if I would have read that information, it may have changed my analysis. Was I provided a supplement?
I did not provide it, so I do not know what Mr. Gurmurthy did, and I apologize. I was out of the state on training last week, so I didn't know they were doing this as a no contest plea until about 20 minutes ago.
Mr. Gurmurthy, did you provide a supplement?
I provided about 14 pages, and that was part of the supplement. So I don't know if that came through or not, but I can certainly re-provide it.
The court's going to adjourn. Counsel, you need to be better prepared if you're going to seek a no contest plea, and you should clearly understand that for this case and every case in the conceivable future for me, if there isn't clear evidence of guilt within information you provide to me, I will not accept a plea, ever. And from what I've read, there is not clear indication of guilt, and I won't accept a plea on that basis. If I've missed something, then I want you to tell me where I've missed it. But I haven't read the things that Ms. Koch just indicated. If those things were provided in a written police report, it might change my analysis. But you're gonna have to do a better job of providing me the information upon which you're seeking a plea to be entered. And frankly, you're gonna have to do it before 20 minutes before a hearing date. Do you have any questions about the court's statements, Mr. Gurmurthy?
No.
Ms. Kenny, I'm going to adjourn. I find good cause to do so because apparently there's information out there that may assist me in making a finding in this case, but we're not going to get there yet because in my view, at least, I have not been provided it yet. So I'm going to set a new hearing next month. You need to stay in contact with Mr. Gurmurthy, and then you can decide ultimately how you want to proceed. Do you have any questions, Ms. Kenny?
No, Your Honor.
Ms. Koch, anything further in light of what's happened so far?
No, thank you.
We'll be in recess and we'll see everybody in about a month for a new status conference. The court will call the people of the state of Michigan versus Gary Williams Spicer Jr. This is file 25-5379FH.
Sierra Cook on behalf of the people.
Gurmurthy, this is your case, correct?
Mr. Spicer, no, Judge, not my case.
I have you listed as the attorney. Was there some sort of substitution?
No, I was never appointed to it.
The certificate of mailing indicates that you got notice for today's hearing on People versus Gary Wayne Spicer on, well, it was mailed out on January 30th. Looking to see if I have any further information in the court file. Did you get the notice in this case?
No, I don't even know what the charges were. Was this bound up from district court or was this a probation violation,
So
Judge?
this appears to be a court error and not a defense error. And when I say that, Mr. Gurmurthy, it looks like Mr. Trush was appointed as attorney back on December 23rd. Somehow notice went to you, but not to Mr. Trush's office. Mr. Gurmurthy, your name appeared on my notice of hearing and pretrial order, but it doesn't appear anywhere else, as you correctly stated that you were ever the attorney in this case. Ms. Koch, do you have any information in your court file about communications with Mr. Trush?
Yeah, we have him listed as the record in our file. We have given him copies of everything. We confirmed addresses. We gave a copy to Mr. Trush on 128.
So I had obviously a concern here. My staff sent a copy to Mr. Gurmurthy. That must have been an oversight, an error. What notice was sent to Mr. Spicer? However, I'm not going to address this case any further. Mr. Gurmurthy got notice but obviously this wasn't his case. He's not prepared to address anything, and it appears that Mr. Truish, who is Mr. Spicer's attorney, did not ever get any notice. Is Mr. Spicer here in the courtroom today? You know, answer, I'm not going to address the matter further. I am concerned that Mr. Spicer's not here. It appears clear that he got notice of today's hearing, but his attorney's not here, and his attorney has a right to be heard. The court's going to just renotice this matter for next month, make sure proper service is provided to Mr. Truish as the attorney of record, and then we'll hear from Mr. Spicer hopefully as well. Anything further on that matter? So
No.
the court's going to bring in Moto G here, see if we can identify that individual. Mr. Patel, have you had enough time to talk with Mr. Thompson? The question for you, Mr. Patel, not Mr. Thompson. Have you had enough time to talk to him? Yes. The court brought into the hearing room a Moto G Pure. Whoever's on that device, can you please unmute yourself and tell me who you are?
My name is Gary Spicer.
I'm sorry, can you tell me again?
Gary Spicer.
Mr. Spicer. Mr. Spicer, I'm Judge Hunter. I want to go back through the basics. I'm glad that you're here, number one. Number two, the court made a mistake and provided notice to the wrong attorney in this case. That, of course, had nothing to do with you and nothing to do with the prosecutor. That's on the court. We provided notice to an attorney who was not the correct attorney. So your correct attorney, Mr. Truish, was never given notice of this hearing today. So what I'm going to do is simply adjourn. I'm going to set a new hearing date. I'm going to correct the error that we had, and we're going to make sure Mr. Truish is here and ready to advocate on your behalf. Do you have any questions?
Oh, okay. No, Your Honor, I don't.
We'll see you next time. Make sure and be on time and know what time you're expected to be in court. Thank you, Mr. Spicer.
Yes, Your Honor.
That was a whole lot of fun. Oh my gosh. Mr. What was his name? Mr. Burns? No. That wasn't it. Hold on. It's in the chat here. Mr. something or other. He was just, oh. He really was putting me to sleep. Anyway, Bruce, Mr. Bruce. That's it. That's it. Yeah. He started it. He was putting me to sleep. And I even started early, knowing that I had, you know, a really long caseload of all good stuff. And I was like, yay, I can make replay crew minis out of it. I can't make replay crew minis when Mr. Bruce puts me to sleep. Because you guys understand. You guys know that I have narcolepsy and sleep apnea and all that other stuff. But brand new people finding the channel don't know all that stuff. So it just looks like I'm either sleep streaming or like I'm intoxicated on something. But I just got random drug tested like 2 days ago at my doctor's appointment, and I passed. So I have proof. Oh, yeah. Thank you guys for coming out. But I'm going to go to bed now. Not really, but thanks. I love you guys so much. Be safe, be well, sleep sweet, and much love.